Доброго ранку, шановні учасники конференції. Доброго ранку, вельмишановний пане голова Верховної Ради України Дмитре Олександровичу. З великою повагою Джаніні Букікіо. Наші привітання. Доброго ранку, Валентина Іванівна, голова Верховного суду. Шановні учасники конференції, дозвольте привітати всіх з початком роботи міжнародної онлайн-конференції, яка проводиться в рамках Конституційного тижня, присвяченого до Дня Конституції України, з темою конференції «Взаємні здобутки Європейської Комісії за демократію через право і органів конституційної юстиції та проблеми тлумачення в конституційному судочинстві», яку ми присвячуємо 24-й річниці Конституційного суду України та 30-річчю утворення Європейської комісії за демократію через право. Для Конституційного суду України День відзначення прийняття Конституції Незалежної України щороку знакова подія. У 96-му році з'явився не тільки справжній об'єкт захисту з боку органу конституційної юстиції, Українська Конституція, як цілісний документ, у якому зафіксовано основні цінності демократичного суспільства і вперше визначено національний каталог прав людини і громадянина, а й засновано вперше в історії нашої держави орган конституційної
history of the Ukraine, the body of constitutional justice appeared. That's the Constitutional Court of Ukraine. As the day of the Constitution is approaching, we are about to mark it. 30 years ago, Venice Commission was established. It's another anniversary. And we are very much rewarded that our conference is attended by the head of the Ukrainian parliament, Dmytro Razumkov. It's my great honor to hand the floor over to him. Good morning, Mr. President of the Constitutional Court. Good morning, dear judges. Good morning, President of the European Commission for Democracy through Law. We are working online because of the issues faced by the entire world and by Ukraine, but we hope that in the future we'll be able to conduct such meetings face-to-face. Dear colleagues, I'm very thankful to you for the invitation to take part in this conference. I'm very pleased to participate in this event on the eve of the 24th anniversary of the adoption of the Ukrainian Constitution. Ukrainian parliamentarism will also mark its 30th anniversary soon, which is of particular importance for the Verkhovna Rada and for our colleagues from the Constitutional Court. I greet and congratulate Mr. Bukikyo on occasion of the 30th anniversary of this commission. For 30 years, it is playing a very important role in improving the Ukrainian legislation. We are very grateful to you for the assistance our nation has been receiving. And may I also remark that we are very grateful for having considered my request about an opinion on the draft law on the referendum. The Constitutional Court of Ukraine faces many challenges, as well as the Ukrainian Parliament, and we are very grateful for the constructive cooperation and support. I am certain that the Parliament and the Constitutional Court are progressing together in order to make our Constitution fully implemented. lamentable, and we often find our common ground in spite of different views that sometimes exist. Discussions are always conducive to the emergence of truth. So we are very thankful for the support we are receiving in many domains. The Constitutional Court and the Verkhovna Rada are working in concord for the sake of qualitative changes to the laws of Ukraine. It is also very important to identify the deficiencies in the existing laws and to figure out how to resolve such situations. Dialogue is needed for that, as well as cooperation. And there should also be good understanding that all institutions work for the Ukrainian state. May I assure you that the Parliament of Ukraine is ready to further deepen cooperation and mutual work, and we are very appreciative of all information that we receive from the Constitutional Court. Thank you, Mr. Razumko, for your understanding. And let me assure you that the Constitutional Court is fully geared to cooperate with the Parliament of Ukraine, with our legislators. And we hope that our joint efforts will continue. We hope that the Parliament will pass such laws that will decrease the number of actions lodged to the Constitutional Court of Ukraine. We can achieve that together. And we are ready to open a dialogue and cooperation. And in fact, this conference is not a ceremonial activity. We hope that it will give a practical impetus to our work. This conference will be attended by many renowned Ukrainian and European academics. Thank you for having participated. Thank you for having invited me. Gianni Boccicchio, President of the Venice Commission. Let me also address all other members of the Venice Commission. We welcome all members of the Commission and the Commission on occasion of the 30th anniversary of its establishment. On behalf of the justices of the Constitutional Court of Ukraine, I congratulate you on this occasion, the 30th anniversary of your existence. The Commission has become a real forum for the European constitutional dialogue on the basis of rule of law, respect of human rights and other values. It is also important to remark on the important contribution of Venice Commission into the development of Ukraine as a law-governed state and all the constitutional and legislative reform. We appreciate the opinions of the Commission regarding the laws on the changes in the Ukrainian legislation in the context of compliance with the international standards. We thank the Commission and you personally for the support that has been given to the Constitutional Court of Ukraine. It is my pleasure to note that an important landmark of our cooperation is the amicus curiae opinion, and we are very grateful to you and to your colleagues for many years of cooperation. And we hope that our partnership will further deepen and develop to the benefit of constitutional justice of Ukraine and the principles of democracy, rule of law, and protection of human rights in Ukraine and throughout Europe. I wish you and your colleagues good health, well-being, and new achievements in your important activities. And it is my pleasure and my great honor to give the floor to you, Mr. Bukikyu.
Mr.
Bukikyu, the floor
President
is
of the
yours.
Constitutional Court of Ukraine, dear head of the Verkhovna Rada, Madam President of the Supreme Court of Ukraine, Excellencies, dear colleagues, ladies and gentlemen. While I'm pleased that it is possible to address you via internet connection today, I would certainly have preferred meeting you in person in Kiev. In these difficult times, video conferences have become a regular means of exchanges, but they cannot really replace meeting people and discussing important issues of constitutional law face to face. Sometimes the most important part of conferences are the coffee breaks and the social events where we can discuss bilaterally, where we can gauge eye to eye areas of agreement and cooperation. I'm grateful for your initiative, Mr. President of the Constitutional Court, for proposing the organization of this event when we met in Strasbourg last January. Then we could not know that traveling to Kiev would not be possible, but I welcome that you have been able to organize this conference nonetheless. Mr. President, the COVID pandemic struck all countries with unprecedented vigor. In order to ensure the health of the people, all our countries had to take measures that seriously limited human rights. While most of these measures were indeed justified and proportionate, some of them did exceed these limits and had to be struck down. The Venice Commission took up this challenge and provided advice to the Secretary General of the Council of Europe for her guidance to member states on, and I quote, respecting democracy, rule of law, and human rights in the framework of the COVID-19 sanitary crisis. The Venice Commission was well placed to do so because it had dealt with the constitutional and human rights implications in emergency situations since 1992 and adopted a study on this matter in 1995 already. In numerous opinions for Armenia, France, Georgia, Kyrgyzstan, Montenegro, Romania, Serbia, Tunisia, Turkey, and of course, Ukraine, the Commission has addressed various aspects of emergency situations, including the declaration of the state of emergency, its oversight, which is very important, by Parliament and by the judiciary, the limits on the scope and on the duration of emergency measures, or the possibility for constitutional amendments and elections during states of emergency. In opinions and in the rule of law checklist, the Venice Commission insisted that state security and public safety can only be effectively guaranteed in a democracy which fully respects the rule of law. Following the recent publication of a compilation and reflections on this topic, the Venice Commission currently prepares an emergency power observatory, which will provide the basis of a general report on this topic to be adopted later this year. Mr. President, I'm grateful to you for convening this conference also at the occasion of the 30th anniversary of the Venice Commission. During these 30 years, our cooperation with Ukraine was incredibly intense. I counted that since 1995, the Venice Commission adopted no less than that 96 opinions for Ukraine. 4 more opinions, and we have another event to celebrate today. Indeed, I can say that Ukraine has been the best partner of the Venice Commission since its creation. Obviously, I cannot present all these opinions. They cover a very wide range of topics, from constitutional amendments, laws on the judiciary, electoral legislation, political parties, the role of the opposition, minorities, autonomy and decentralization, language, the fight against corruption, lustration, and of course, on the legislation of the Constitutional Court. I particularly welcome that the Constitutional Court started requesting amicus curiae briefs from the Venice Commission, and I would encourage you to continue doing so when elements of comparative law are relevant for the judgments of your court. The Constitutional Court of Ukraine has an essential role in safeguarding constitutionality in your country. The independence of your court is key to sustainable progress of democracy, the protection of human rights, and rule of law in Ukraine. Maintaining independence and impartiality is a responsibility of the court as such, and of each of the judges of your court. You owe your loyalty to the Constitution only, and as a constitutional judges, you have the famous duty of ingratitude towards the body that appointed you to this position. In March, I publicly welcomed your judgments on the judiciary, which annulled the reduction of the number of judges of the Supreme Court and thereby strengthened the independence of the Ukrainian judiciary. I hope that the reform of the judiciary, which already has brought positive results in recent years, will continue, and that the vacancies in the judiciary will soon be filled so that the people of Ukraine can benefit from an improved judicial service provided by judges who are both professionally qualified and immune to corruption. I've just learned today that a new draft law on the reform of the judiciary has been submitted to the Verkhovna Rada. The Venice Commission is, of course, as usual, available to cooperate with you, with your authorities in this field. Furthermore, I'm pleased to learn about progress also in respect of another opinion of the Venice Commission. Recently, indeed, the Minister for Foreign Affairs of Ukraine assured that Ukraine will follow the recommendations of the Venice Commission as concerns the law on education. I hope that this will help setting a dire dispute. Ladies and gentlemen, today we celebrate the day of the Constitution of Ukraine. The Constitution is the pivot point that provides essential stability. It is the basis for agreement between various interests, between majority and opposition, between authorities and civil society, between speakers of all languages spoken in Ukraine. I call upon all Ukrainians to make use of this constitution as a rallying point that provides guarantees and freedoms for all of you. You have rightly different views and opinions, different interests and aspirations. Make the best out of this constitution, which ensures that views and interests are safeguarded for the benefit of all Ukrainians. As in the past, the Venice Commission, dear President, stands ready to assist Ukraine also in the future on this path. Thank you very much for your attention.
Дякую вам, пане Букікіо.
Thank you, Mr. Bukikio, for this high appreciation of our relations with the Venice Commission and your high appreciation of Ukraine's steps towards enhancing democracy. I do agree that our cooperation with Parliament encourages us to develop these trilateral relations. And with the same, I'm for the laws to be compatible with the Ukrainian constitution, European values, and would protect rights and freedoms of the human being. Today we will be speaking a lot about it because the topic of our conference is mutual achievements of the European Commission for Democracy through Law and bodies of constitutional justice and the problem of interpretation of the constitutional adjudication. And we have as participants members of the Venice Commission, judges of the European Court for Human Rights, justices of the Supreme and Constitutional Court, and we will focus on these issues today. We will be discussing current challenges while we start the panel discussions proper. But as the introductory remarks, I would like to say that this conference is being supported by the OSCE Project Coordinator in Ukraine, with whom we cooperate most closely. We've got an MOU, shorter term and longer term programs, and we work to fine tune the areas of our cooperation, adjusting them to the current crisis. And this conference and our further cooperation with OSCE PCA inspires us as a promise for future results. And it is my great pleasure to give the floor now to Ambassador Henrik Willertsen. The floor is yours.
Thank you very much. Your Excellency, President of the Constitutional Court of Ukraine, Judge Stupitsky, dear Chairman of the Verkhovna Rada, Your Excellency, President of the Venice Commission, Judge Gianni Bucchicchio, distinguished judges of the Ukrainian Constitutional Court, distinguished members of the Venice Commission, ladies and gentlemen, distinguished colleagues, dear guests. I'm honored to be invited to give this welcome address on the occasion of this event that has gathered together justices of the Constitutional Court of Ukraine, members of the Venice Commission, distinguished colleagues from other countries, exceptional scientists from across our region, all dear colleagues of law. Despite the difficulties we are facing now due to global pandemics and the need to master new telecommuting tools and social distancing, this event offers us a unique virtual platform that bridges us geographically and temporarily, I hope. Geographically, because this event is stretched across Europe from Kiev to Strasbourg and beyond, and temporarily as we celebrate both the 30th anniversary of the Venice Commission, a true beacon of rule of law in the world, and the 24th anniversary of the Ukrainian Constitution, to be held in a couple of days. On behalf of the Organization for Security and Cooperation in Europe, I wish you happy anniversaries. The COVID-19 pandemic has turned our world upside down, causing tragic loss of life and disrupting our social and economic order. The rather chaotic global response to the coronavirus pandemic has tested the faith of even the most ardent internationalists. Most nations have turned inward, adopting travel bans, implementing export controls, hoarding or obscuring the spread of information, and marginalizing multilateral institutions. The pandemic seems to have exposed the liberal order and the international community as mirages, even as it demonstrates the terrible consequences of faltering global cooperation. What is no less disturbing is that in many countries we witness a steady recession of the rule of law and democracy, as some political regimes are trying to seize the COVID-19 induced momentum to consolidate power to the detriment of constitutional rights and freedoms throughout the world. If democratic backsliding further intensifies, then we can add another casualty to the terrible toll already inflicted by the coronavirus: the demise of democracies that were too fragile to withstand the authoritarian inclinations of their leaders. I hope we do not get that far. This somewhat dire context gives a new meaning to our event of today. Both the Venice Commission and the Constitutional Courts remain the bulwark of democracy and the rule of law, also in these troubling times. Values heralded in the 1990s, liberal democracy, constitutionalism, and human rights, are under attack. People throughout the world feel less secure than ever before since the end of World War II. Only by joining our efforts can we withstand this turmoil. Excellencies, ladies and gentlemen, some occasions provide unique opportunities for change. Such opportunities must be grasped while they are available. If not, there may be years before the opportunity reappears, or it may never reappear again. Our event today is such an opportunity for change. The Constitutional Court is more in need of dialogue with the people and multilateralism than ever before. The OSCE Project Co-ordinator in Ukraine, the diplomatic mission that I am privileged to lead, has been an effective tool to this end in the past and stands ready to continue our cooperation with our good friends of the Ukrainian Constitutional Bench. And this event today is a good example of how we can solidify our efforts. I would like also to take this opportunity to thank the Venice Commission for its kind support in its designation of 3 special advisors to the Constitutional Court of Ukraine, who are retired judges of the European Constitutional Bench and are providing consultations to the Constitutional Court of Ukraine's members on international best practice on direct constitutional complaint. I would like to extend no less my sincere gratitude to the Ukrainian Constitutional Court for our years of long and fruitful cooperation, which I am sure will stretch far into the future. I wish you all a good and productive time today. Thank you for your attention. Дякую. Have a good day.
Дякую, пане посол. Ми в постійній співпраці.
Thank you, Ambassador, sir. We are cooperating for a long time now. We've got an MOU for 3 years of collaboration, and we have planned our next activities, and I'm sure that working together we will be successful in implementing those programs. And I will notify the participants of the conference that it was thanks to OSCE PCU that we launched a training classroom at the beginning of the Constitutional Week. It has been equipped with the necessary machines and mechanisms, hardware and software to communicate under the conditions of pandemic, to ensure professional development and exchanges amongst professionals, holding and hosting online conferences in order to continue our cooperation and communication. Of course, face-to-face communication is much better, but with nothing else to do, we have to bear with this. Quite recently, we had an online conference with the Council of Europe and got a lot of useful information and recommendations on how to treat certain particular challenges and cases. So I'm extremely thankful to OSCE PCU for this cooperation, and I hope that we will live up to our mutual expectations, both institutionally and personally. Thank you. From the very first days of the existence of the Constitutional Court of Ukraine, it has cooperated with the German Foundation for International Legal Cooperation. We have very close ties with the fund. We have had several expert meetings, panel discussions. We do that several times a year. And justices and workers of the court have an opportunity to discuss most topical issues. We also have an opportunity to talk to our peers in the Constitutional Court of Germany. Quite recently, 142 MPs filed a constitutional petition for us to actually explain and provide the interpretation of the notion of dignity. And we will rely on the court law of, or case law of the German courts, who have got a lot of material in this area. So I will now give the floor to Mr. Stefan Holzhorster to the floor. The floor is yours. You're welcome.
Дуже вам вдячний. Dear Mr. President Tupitsky, dear Mr. Chairman of the Verkhovna Rada, dear judges of the Constitutional Court, dear Mrs. President of the Supreme Court, dear Mr. President of the European Commission for Democracy Through Law, and dear Mr. Ambassador of the OSCE, ladies and gentlemen, and dear friends. First of all, I also would like to congratulate Ukraine, the Constitutional Court of Ukraine, all judges and all former judges of this court on the occasion of the Day of the Constitution. May the constitutional system of Ukraine and the Constitutional Court develop and prosper in order to further strengthen and consolidate the rule of law governed Ukraine. It's a pleasure for me taking part of this online conference, and I thank Mr. President Tupitsky and all his colleagues in charge for hosting this conference, the Venice Commission and the OSCE for taking us along on your web-based journey. Nevertheless, also me, I have to admit that I'm old-fashioned enough to rather be in personal contact with you, but as long as Corona prevents us from personal meetings, it's far better to meet and to discuss online. So as you all might know, the German Foundation for International Legal Cooperation is commissioned by the German federal government, especially by the Federal Ministry of Justice and Consumer Protection, to cooperate with its partner states in various fields of legal reforms. Ukraine and the IRZ are linked by a long-lasting and fruitful cooperation since the early 90s, as Mr. President Tupitsky already said. The very first delegation IRZ hosted at our headquarters in Bonn was from Ukraine. And since then we had, and we have until today, a close and trustful cooperation with the Constitutional Court of Ukraine, for which I'm very grateful. We are proud that we were able to be accepted accompany and to support the Ukrainian partners on their sometimes a bit stony path through different stages of reform efforts. The Constitutional Court plays, as my previous speakers already said, an important role within the rule of law governed system of Ukraine. Since the constitutional complaint was established, it has gained even more acceptance within the whole society because of its function as constitutional control. This important role in mind, for which a strong backbone of every single judge is necessary, we since mid-90s enabled a constitutional dialogue between German and Ukrainian constitutional judges. Several times, the presidents, vice presidents, judges, and retired judges of our Federal Constitutional Court in Karlsruhe visited Kiev and vice versa. As I mentioned already, the personal contact and the personal exchange of practical experience are, in my opinion, of utmost experience and importance. But better than silence is online cooperation, and so we do. We are offering to our partners, so as to the Constitutional Court, to organize these small-scale but very effective and intensive expert meetings online. Interpretation of constitutional law, topic of today's conference, always was one of the central questions of our expert meetings. Interpretation of constitutional regulations like the Catalogue of the Human or Basic Rights of the Ukrainian Constitution will be even more important in case Ukraine will introduce a full constitutional complaint. Therefore, in order to strengthen European standards of constitutional law and of constitutional jurisprudence in all our countries, an open and trustful expert dialogue is crucial and indispensable. And so I'm very happy that my German colleagues, Professor Rainer Arnold from Regensburg University, by the way, one of my doctoral supervisors, and Dr. Lars Brocker, President of the Constitutional Court of Rhineland-Palatia, both reliable and good friends of Ukraine, take part today. Today's conference is one more pearl in the long chain of reform efforts, and thanking for your patience and attention. I wish you all very interesting discussions. Дуже вам вдячний.
Дякуємо, пане Штефан.
Thank you, Mr. Hulshorster.
Over these years, we have developed much mutual confidence in our relations with our German partners, which helps us to resolve the issues we confront. Thank you very much for your assistance and your initiative. We continue our proceedings, and in due course I will give the floor to serhiy.peremot, member of the European Commission for Democracy through Law. But before that, I will say that the Constitutional Court of Ukraine is always attentive to different international instruments and opinions, including the opinions of the Venice Commission. It expresses its opinion on the constitutional law. These opinions have been guidelines for us. After 2015, new tendencies have emerged, and I just have to mention two judgments passed by our court before 2015. But after 2015, we referred to the opinions of the Venice Commission in 16 judgments and in 6 other documents, which means that the Constitutional Court of Ukraine takes into account everything that comes from the Venice Commission that is pertinent. So the key points are rule of law, democracy, referenda, organizations of citizens, people's deputies of Ukraine, the judicial system. And there's aspects as well as some history of the Constitutional Court's jurisprudence will be tackled by serhiy, member of the European Commission. Thank you very much. Dear Chairman of the Constitutional Court, dear President of Venice Commission, dear ambassadors, dear colleagues from the Constitutional Court, dear colleagues from abroad, dear academics, ladies and gentlemen, this year of 2020 is rich in different anniversaries. Venice Commission marks its 30th anniversary in 3 weeks. Ukraine will mark 30 years of the Declaration of Sovereignty of Ukraine, which was proclaimed in the times of the USSR and communist regime. However, in the last line of the declaration is said that it will serve as the basis for the new constitution of Ukraine. In July 1990, no one could predict when the new constitution would appear because it was hard to imagine independence of Ukraine as a state, as a nation. We are also marking the 30th anniversary of Venice Commission. Cooperation between the Constitutional Court of Ukraine and Venice Commission began much earlier, before Ukraine received its constitution, because the constitution appeared in 96, but before that, our predecessors paved the way for fruitful cooperation with the Venice Commission. I remember, Mr. Bukiki, our very first meeting in March 1990 in Bologna Trattoria, where your body always meet, and I came up with a sad news that on the way to Venice, the president of the Constitutional Court, Leonid Yuskov, died. It happened on the 2nd of March of 1990. Ukraine was not a member of the Council of Europe back then. Ukraine was not a member of the Venice Commission, but the Constitutional Court of Ukraine had been established, and in 1992, Leonid Petrovich was elected as the president, and he and President Kuchma's team, president's advisors and counselors, were figuring out how Ukraine could advance into the European space and build its future. And then another important date occurred, the 5th of June of 95, 25 years ago. That was the date of the constitutional agreement between the parliament and the then President Kuchma. Ukraine was not a member of the Council of Europe, was not a member of the Venice Commission, but the Venice Commission had played a crucial role for Ukraine's advent to the Council of Europe, because what Mr. Yuskov initiated, specifically that idea of the constitutional agreement supported by President Kuchma's political team, was later approved by Venice Commission. In June 95, Venice Commission said that this agreement could serve as a mini constitution, and on the basis of which Ukraine received a green light for becoming a member of the Council of Europe. And it was really a unique occasion. A new independent state did not have its own constitution, but it has become a member of the Council of Europe. And thus cooperation that was started by our cooperation has been developing until today. And as President Bukikio said, 96 opinions about Ukraine were written by the Commission, plus 4 memoranda from the Secretariat of Venice Commission about the process of our cooperation. So it's really 100 in total. And, well, 100 documents in 25 years of cooperation. That is really a lot. That this is no small number by any means. The Commission helped Ukraine to be up to its commitments and obligations to the Council of Europe. We share the values professed by the rest of Europe: democracy, human rights, and rule of law. When the Venice Commission came up with its opinion about the Constitution of '96 and said that this Constitution had good elements of rule of law and stipulated its principle, many of us could not understand what it really meant. We were very proud that we were the first and only post-Soviet state that in its own constitution stipulated the principle of rule of law. We were the first and the only one. Maybe we acted intuitively without proper knowledge, without good understanding of what rule of law signified. But once again, the Venice Commission played its crucial role because it issued 2 documents, the opinion of 2011 on the rule of law and the checklist of 2016. And within our academic community and within our judicial corps, this is a very substantial source of new law to be reflected in our constitutional legal order. Venice Commission has been closely following the development of the Ukrainian constitutionalism, and we are very grateful to the Commission. And we maintain our aspirations to membership in the EU, and once again the Venice Commission was crucial, and all Ukrainian authorities hold Venice Commission in much respect, unlike the authorities of some other countries. And all Ukrainian authorities have been very attentive to what Venice Commission had said. I should recall the reform of 2016. Everything that was recommended by the Venice Commission regarding judiciary or constitutional justice or the entire legal system, everything was taken into account. That was the culmination, the summit of cooperation between Ukraine and Venice Commission. And our successors will have also to do much. For example, getting rid of the political influence on the prosecution authorities. The Venice Commission also recommended a selection of judges by special qualified majorities. That also concerns members of the High Council of Justice or those judges who are nominated by the Congress of Judges. This is really not a very complex task. We are on our way to European integration, and this is something that should be done by our successors. And to conclude, Mr. President, in view of our long-lasting cooperation, I will say the following.
Educating and cajoling Ukraine into the institutionalization of the rule of law has had a profound impact on Ukraine's unalterable orientation to the European family of democratic nations and traditions. In effect, the Venice Commission created solid backbone for the Ukrainian legal system, which is compatible, not fully yet, but in major elements with the European standards. And I am sure that fruitful cooperation between the Venice Commission and Ukrainian authorities will continue further. In general, when you are speaking about 100 documents, and especially in the rule of law area, 28 and 2 amicus curiae, can you imagine the agenda of the Venice Commission for this period? Almost 3 plenary meetings a year were devoted to Ukrainian issue during all these years. So the cooperation between Venice Commission and Ukraine contained in the Commission's 100 documents, and especially 28 opinions and 2 amicus curiae with regard to the rule of law, reflect a copious amount of intellectual nourishment, substantive legal doctrine, and impressive practical guidance, all of which comprise the triad of the European common values: genuine democracy, human rights, and the rule of law. And because of the crucial role played by the Venice Commission, all of which now form the core of Ukraine's legal and body politic. Thank you very much. Дуже дякую всім за увагу. І за програмою ми мусимо переходити до
And thanks everybody, and in accordance with the program, we move to our first panel, where we shall discuss constitutional control as a mechanism for resolving conflicts of interpretation. Let me again thank the President of the European Commission for Democracy through Law. We are very rewarded by the fact of participation of Mr. Holovati in this conference. He is not only a member of the European Commission, but also a Justice of the Constitutional Court of Ukraine, and which means that we are really learning from the Venice Commission. And now I am announcing our first panel. But before that, I will thank Mr. Zumkov, Chairman of the Verkhovna Rada of Ukraine. Thanks very much for having participated in our conference. It's being broadcast, and the words you address to the Constitutional Court, to our international partners, and to all the experts who attend this event are important for us. because they show recognition of the work we do and inspire us to further efforts and cooperation. Thank you, Mr. Razumko. Thanks very much, Mr. Chairman, for the invitation to take part. I wish your conference much success and effectiveness. Have a nice day. Thank you. Thank you. Goodbye. And now the first panel. It will be moderated by Serhiy. Dear colleagues, as per the program, the first panel will address constitutional control as a mechanism for resolving conflicts of interpretation. It's my pleasure to introduce the team that will address these issues. They represent different professional domains. Armen Arutyunyan is a person of much experience. He used to be a member of the commission that was working on the constitutional reform of Armenia. He was an advisor to the Constitutional Court of Armenia. He also represented Armenia in the Venice Commission, and now he is a judge of the European Court of Human Rights. So it's a lot of experience in the national constitutional jurisprudence, in the Venice Commission, now in the European Court, and we are really anticipating his speech. I don't think that I have to especially introduce Valentina Danishevska, who chairs the reformed Supreme Court, formed after the reform of 2016. So the relevant realm is general justice, and we'll certainly compare interpretations by the Constitutional Court and by general courts. And Alexander Petreshin is the president of the National Academy of the Law Sciences of Ukraine, and it will be interesting to hear about constitutional control from an academic. So, but before I give the floor to the first speaker, I will remark that for us, this topic is very practical because of Article 89.3 of the law of the Constitutional Court, which reads that the Constitutional Court, when examining constitutional complaints, may conclude that a certain rule in a piece of legislation is not unconstitutional, but general courts or courts of general justice, criminal or civil or administrative, could have interpreted such a rule in a manner that is not compatible with the Constitution and the principles stipulated therein. So this is really a specific Ukrainian issue that entails multiple practical problems, and we'll certainly hear also about relevant theoretical issues. So now it's my pleasure to give the floor to Judge of the European Court of Human Rights, Armen Arutyunyan.
Will I continue? Yeah. So thank you very much, dear Chairman of the Constitutional Court of Ukraine, dear participants, and dear ladies and gentlemen. When President of our court invited me to take a part of this conference, I accepted it with great pleasure because and Venice Commission and Ukraine I had a very interesting period of time when I was working there. So my congratulations with the 24th anniversary of the Constitution. And I remember that before coming to the European Court of Human Rights, I was a head of the Human Rights Monitoring Commission established by the UN High Commissioner of Human Rights. And our monitoring mission prepared first 11 reports for UN Security Council about the human rights situation in Ukraine. It was March of 2014 until September of 2015. Quite a difficult period and quite an interesting period of Ukrainian history. And of course, 9 years out, I was an active member. Now I'm a passive member of the Venice Commission, because Venice Commission is something like family, and we don't have former members of the Venice Commission. And I agree with Mr. Holovati that Venice Commission did have a serious contribution for establishing the democracy and rule of law, and its geographical cover quite worldwide, because I know how it was effective and for Armenia, but not only for Armenia. When I was the head of regional office of United Nations Human Rights in Central Asia, I remember how Kazakhstan and Kyrgyzstan were actively engaged with the Venice Commission. So, dear colleagues, coming to our today's topic, this is a really very actual and very important one. And I decided not to go into the judicial technicalities, what kind of control we have, what kind of the conflicts of interpretation we could have. This is the one issue. I think, first of all, we have to be focused on methodological problems, because there are different theories of statutory interpretation, textualism, the theological interpretation, non-categorical theories, or constitutional interpretation, the originalism, living constitutionalism. But I would like to start from judicial review, which and constitutional review is a part of that. And of course, after I will articulate the independence of judiciary, democracy, and rule of law. These are very important, and as a composition, as a constellation of different principles, they are important very much. A traditional issue in constitutional theory is the legitimacy of judicial review. Are courts entitled to review the constitutionality of democratically enacted legislation? There have been various ways of understanding these questions. Some of these are: does the Constitution authorize judicial review? Did the framers of the Constitution intend courts to exercise judicial review? Is judicial review compatible with the democratic theory? And is judicial review compatible with the political system of the given country? Judicial review is the power of the judiciary to declare legislation unconstitutional. This one we are calling interpretative judicial review, or not unwise policy, non-interpretative judicial review. The source of this power and its limits is usually granted by the Constitution itself or the judgments issued by the Constitutional or Supreme Courts. And the problem is, and I would like to underline this, how the separation of power will proper function, and whether judicial review will substitute the will of the judiciary for the will of the legislator. The separation of governmental function is understood as follows. The legislator is supposed to make a law, the judiciary is supposed to interpret and apply the law, and the executive is supposed to enforce the law as interpreted by the judiciary. The division of labor between the legislature and judiciary has a democratic issue. But here I would like to delimitate two things: institution and function, because constitutional control, yes, but constitutional and institution which is entitled to provide this function must be independent. And there are some requirements for this institution, because if these requirements are not met, constitutional control will not be effective for the country. Yet in 1984, in paragraph 78, the European Court of Human Rights, in the case of Campbell and Fell, underlined and emphasized 4 elements in order to decide whether the judiciary is independent or not. First, the manner of appointment of members. Second, the duration of term of office. Third, the existence of guarantees against outside pressure. And the fourth one, whether the body presents an appearance of independence. And this is a very important, because non-independent body cannot be an effective remedy for providing constitutional review. And from this point of view, we are coming to the next question. I will outline the questions, and after, if will be questions, I will respond. The effective remedy. In order to be effective remedy, Constitutional Court, or if there's a Supreme Court which is entitled to provide this function, should be sufficient and available, not only in the theory, because a lot of things can be written in the Constitution, but we know the written Constitution and a live Constitution, and the difference between them shouldn't be very big. And in the practice, and the body which is entitled to provide constitutional review has to have sufficient powers and safeguards. Of course, we cannot ignore and disregard here such a basic principles as a democracy and rule of law. In fact, courts should rely on the following basic principles by interpreting the legislation, the rule of law and democracy. Effective constitutional control is possible only when there is a democracy. Only under such conditions, the real existence of effective remedies is possible. If we endeavor to provide a concept of the court's approach toward democracy and rule of law, then democracy is the regime that guarantees the protection of minorities' interests. This is a possibility to change from a minority to a majority through free elections. A democratically elected majority doesn't yet mean that it is a democratic itself. For this, it is necessary to follow the rule of law. Otherwise, the regime of dictatorship of majority will exist. Authoritative rule of law majority then transforms into dictatorship system of a minority. And as a constitutional lawyer, I'm calling such a regime as a radical democracies. The democratic regime based on the rule of law is the only environment where the effective function of the judiciary is possible. Democracy is the regime where the rule of law is the principle, and the effective constitutional control is the object and purpose within the context of our topics. The regime, principles, purposes, and effective mechanisms are interrelated. One cannot exist without the other. And one very important thing I would like to emphasize as well, post-war, I mean the Second World War, democracy was organized in response to the authoritarian parties came to power through competitive elections. This is why non-majoritarian institutions like constitutional courts, it is very important to remember that particularly constitutional courts should be considered as a non-majoritarian ones. If they are not matching this characteristic non-majoritarian, they will not be able to provide real constitutional control. That's why the non-majoritarian institutions like constitutional courts, or in general, institutions entitled to provide constitutional control, powerful and most trusted. Constitutional control is a non-majoritarian function, and bodies entitled to conduct it requires many factors to be able to implement it. And first of all, without which it is not possible, it is a political will to go in this and to be able to frame constitution in a way when that guarantees will be given to the and to provide that constitution be alive, a document, because constitution is a social contract, and Ukrainian social contract, we have in Council of Europe 47 different forms of social contracts, written, mixed, non-written ways, but these all are pillars of the European public order. And it is very important that constitution doesn't be very formal one. And in this regard, I would like to stress one very important thing. This is dynamics of current world, because we have to be to accept that the current world is facing some corrosion, some deficiencies of the rule of law and democracy, and the nicety of the modern global situation lies within the fact that very often the political majority, having lost its position in the society, tries to retain power by using an administrative resource and manipulative technologies. It leads to the fact that the political majority sitting on the administrative resource becomes a minority within the society. And there is a suppression of opposition and total disregard of the individual's dignity, the basis of fundamental rights and freedoms. And the political majority loses its position because it tries to govern not on the basis of rule of law. It gradually evolves into the dictatorship of the majority. Therefore, having lost public support, the dictatorship of majority is transformed into the dictatorship of minority. This is the transition from democracy toward the radical democracy. Dear colleagues, I, in fact, decided to underline these several requirements for the constitutional bodies which are entitled to implement constitutional reform, because I know very well the situation, and from the perspective of Council of Europe, and as a former high official of United Nations, and as a former Armenian ombudsman. And I passed 2 revolutions. When I was the head of the regional office responsible for human rights in Central Asia, I passed through revolution in Kyrgyzstan. From 1914 to 1915, about 1.5 years, I was in Ukraine, and I know how started and the dynamics of Ukrainian revolution. And you know that 2 years ago happened a revolution in Armenia. Just my message is, institutions which are entitled to provide constitutional control, they have to be independent, effective remedy, and they have to have a characteristic of the non-majoritarian institutions. And democracy and rule of law is an environment, real democracy, where it is really possible for such institutions to provide real constitutional control, which will be able to resolve conflicts of interpretation. This is a methodological part. The rest, what kind of conflicts of interpretation we could have, what kind of techniques of constitutional control, this is already judicial technicalities, which much easier to solve if these methodological problems are solved. That is why, if you go through the case law of the European Court of Human Rights, you will see that always European Court of Human Rights is going through the basic principles, democracy and rule of law. For us, principle of subsidiarity and margin appreciation is a very important. But before coming to the European Court of Human Rights, it is very important to exhaust domestic remedies. But domestic remedies must be effective ones. And in order them to be effective ones, they have to be function within the democracy and on the basis of rule of law. Thank you. On this, I would like to finish. And of course, if there will be questions, I'm at your disposal. Thank you very much.
Дуже дякую вам, пане Армене Арутюнян, за виклад.
Thank you very much, Mr. Arutюнян, for actually characterizing this issue. And I would like to encourage all speakers who can hear us or see us. And if you've got any mistake in the program, then please correct it. The time frame for your intervention or presentations is not 20 but 10 minutes, okay? Otherwise we will have to work till night, and we would not keep within the time limits allocated to us. I don't want to be blamed for bad or poor time management, so I encourage you to keep within 10 minutes, okay? And I would like to know that one of the principal issues when we introduced constitutional reform in Ukraine in 2016 was leaning on the recommendations of the Venice Commission and European recommendations that the Constitutional Court should be devoid of the function of the interpretation of the law. So this amendment was introduced into the Constitution. Today, Constitutional Court does not interpret the law, and this function has been transferred logically to general courts, to ordinary courts. Therefore, we will give now the floor to the Chief Justice of the Supreme Court, Ms. Denishevska, and she will tell us how they cope with this function and whether they do at all. And just according to the constitutional order and legal system, this function is now vested in general courts. Ms. Denishevska, you've got up to 10 minutes. The floor is yours. Thank you very much. Esteemed President of the Constitutional Court of Ukraine, esteemed Mr. Bokukio, President of the European Commission for Democracy Through Law, dear partners, Your Excellency, Ambassador Billotson, Mr. Stefan Horstner, dear colleagues, dear partners. It is my great pleasure and honor to greet you all on behalf of the Supreme Court. First of all, I would like to thank the organizers for inviting me to speak on this topic. I would also like to congratulate representatives of the Venice Commission on the 30th anniversary of its establishment. I would also like to avail myself of this opportunity to know the critical importance of the Venice Commission for the Ukrainian development and Ukrainian adherence to the principles of the rule of law and independence of the judiciary. So we understand that the conclusions and opinions of the Venice Commission are of crucial importance. For 3 decades now, those opinions have been a very powerful roadmap to develop the law and interpret it in the way consistent with the rule of law. Moreover, the operation of this institution ensures the existence of interstate consensus and uniform understanding of the European standards of human rights. I would also like to add to what we've heard before, to what Mr. Holovati mentioned before, that this year we are to celebrate 70 years of the Convention of Human Rights and Fundamental Freedoms. And I believe that the European Convention changed the history of Ukrainian judiciary and justice. And now to the topic of my presentation. All countries have the laws written in the legal language, which is a variety of the national literary language. At the same time, the indispensable feature of the language is its multidimensionality and variety of meanings. Hence, the impossibility to interpret the law in a uniform and way with only one meaning. So the humanity has invented artificial languages, for example, like languages of programming, which where actually signs have only one meaning. At the same time, legislation is written in human language. And we cannot predict what changes might occur in the societies and in understanding of the law. Oftentimes, we cannot even imagine all of the circumstances that will sooner or later fall under the operation of this norm, let alone predicting new living conditions to appear in the future, particularly given the rapid development of the humanity.
Amending laws is always a long and complicated process. Laws usually reflected relations that have already become stable in the society, not the relations that may appear in the future. Therefore, a multiplicity of senses in the law is often an instrument due to which judicial practice is ready to adjust law to specific situations in real life and to the changes within the society. History serves us a lot of examples when a rule set in a law in words in time starts to exercise quite a different impact on human behavior, something very different from the intention of the lawmaker. For example, the provision of the US Declaration of Independence. All men are made equal. At the moment of the adoption of the declaration, it was supposed to be about males and specifically about white males. Similar examples shows that a certain extent of ambiguity may not necessarily be deemed a shortcoming of a law because it's for the sake of the development of law. On the other hand, unclarity of a law makes it unusable. Therefore, there is a dialectical clash between legal certainty and the development of law, and we are to look for the balance, for the so-called golden medium. Therefore, there is a need in a reasonable extent of legal certainty and at the same time a reasonable extent of the possibility to interpret laws. Let's address the European Convention of Human Rights. The general nature of its provisions is not a shortcoming. Moreover, the provisions of the Convention, which may seem vague to many, make it possible for the European Court to apply the Convention as a living instrument, and the abstract nature of the provisions of the Convention lets the Court to adjust its case law in accordance with the needs of today. Montesquieu said his famous words about the judge who is the speaker of the law. At that time, it was a very important idea. However, we recall all the attempts to strip judges of their possibility to interpret laws. We can recall what was happening back then in the 19th century in Austria, France, and Russia. They failed because judges cannot become purely mechanical devices for application for laws or logical automatons that generate automatic decisions. Interpretation of laws by courts is a manifestation of development of law and creation of law by judges. As Carl Levelin said, it's a legal truism that nobody knows what a law really means until courts interprets it. And such a role is in possession of the law of the courts of the continental system and of the Anglo-Saxon system. Continental system courts cannot create new rules of law or change the laws. At the same time, the notion of creation of law should not be made synonymous with law drafting. The law acts as it is bade. Therefore, one can suggest that a rule of the law should not boil down just to the words used in that rule. Interpretations should be added. Therefore, the notion should also include interpretation of the laws. Judges have much discretion with regard to interpretation of laws. It is known there is a contra lege manner of interpretation in accordance with the spirit of the law, but against what the words in the law say. Any judge will be able to understand that the scope of the law is limited, and therefore a decision taken by the judge is to rest on the subjective ideas which, in the opinion of the judge, the law points at. This is the so-called concept of reasonable lawmaker. The judge is not to think about the intentions of the lawmakers who passed the law some time ago. Moreover, the legislators were multiple. Rather, the law should be interpreted as it could be understood by an imaginary lawmaker passing such a law today. When hearing disputes, courts apply not only laws, but also the constitutions, because provisions of constitutions are directly applicable. However, no rule can be applied without identifying its sense, that is, interpretation. That's why in hearing disputes, courts also interpret the Constitution. Under Article 147 of the Constitution, official interpretation of the Constitution is done by the Constitutional Court of Ukraine. And one can easily notice the difference between interpretation of the Constitution by courts and interpretation of the Constitution by the Constitutional Court. Interpretations of courts in case hearing are not official or binding. They pertain only to the parties in the relevant cases. But if an interpretation comes from the Supreme Court, it's to be taken into account by trial courts when they hear similar cases. However, courts may go away from the conclusions of the Supreme Court, provide they explain own position. It's an important mechanism which ensures the constitutional principles of no influence on judge, where judges can rule as they wish, and on the other hand, it makes it possible for the law to be developed by courts of first instance. When the Constitutional Court interprets the Constitution, its interpretation is official and binding to all. In other words, in the future, that stipulation of the Constitution, which is officially interpreted by the CCU, is applied only together with its official interpretation by the CCU. Therefore, the text of the Constitution is complemented with the resolutionary part of the judgment of the Constitutional Court, which contains such interpretation. Official interpretation of laws of Ukraine is not a competence of the Constitutional Court of Ukraine. When hearing other cases, like, for example, on reviewing laws with regard to compatibility with the Constitution, the CCU interprets such laws, but they are not, these interpretations are not official. Not a single application is impossible without identifying the sense of the rule. And such identification is interpretation. An official interpretation of laws by the Constitutional Court of Ukraine is very similar to the unofficial interpretation of the Constitution by courts when they hear disputes. In the course of interpretation by laws, the Constitutional Court and other courts should seek such interpretations that the interpreted laws comply with the Constitution. This lays the ground for stability and continuity of the legislation and its credibility with the population. Only if such an interpretation is impossible, the CCU and other courts should conclude on incompatibility of the law with the Constitution. a key feature for resolving disputes should be rule of law. Constitutional control is conducive to observance of the rule of law, so that the strategic vector of the entire state corresponds to this principle. In the 20th century and in the early 27th century, the quest for the proper solution is done in the conditions of globalization. Because of that, of course, have to study the legal approaches and attitudes in other countries or of the supranational authorities. They should be perceived in the positive key, because harmonization of legal approaches makes it possible to reach consensus in all processes which develop law for the sake of a common legal platform and sharing of accomplishments between states, entailing more dynamic development in the future. In the recent time, constitutional and supreme courts of many nations, the European Court of Human Rights and the EU Court of Justice have demonstrated that when they face a complicated issue, they really study the case law of each other. And the network of the Supreme Courts of the Council of Europe also plays a role in this. And I should also stress the importance of implementation of the protocols to the European Convention. I believe that deepening of such interaction in the future will certainly give best possible results in the future. In view of the moderator's wish, I will draw a line here and will thank everyone for attention. Thank you very much, Ms. Danishevska. Thanks very much for your understanding. And now let me hand the floor over to Alexander Petreshin, President of the National Academy of Sciences. We should have broken for coffee 2 minutes ago. And the rule, the right to a coffee break is illusory, but let's not make discriminatory. 10 minutes, please, Mr. Petreshin. Thanks you, Mr. Moderator. I want to thank everybody for having invited me to this conference, and I greet you from Kharkiv. The biggest law school of Ukraine is in Kharkiv, as well as the presidium of our academy. You mentioned theory and theoretical approaches. Let me address them. Sorry, problems with this sound. Interpreters cannot hear the speaker. Sorry, interpreters cannot make out what the speaker is saying. There are both objective and subjective reasons for that. It is really necessary to adjust the principles and norms of the European law and to ensure direct applicability of the constitutional provisions. Some subjective reasons also step in, but all that makes the problem of interpretation more acute. Moreover, our current legislation is not the best possible. Much of hermeneutics is about translation. It used to be the issue of translation of ancient texts into the living languages. The so-called philological attitude to interpretation emerged, and one of the philological methods is still dominating in our Ukrainian jurisprudence. Hence the so-called classical ideal of rationalization in interpretation. The position of an absolute observer, the pure conscience approach, when the interpreter of the law is above all natural and social processes. And this classical ideas of rationalism is seen in the positivist theory, when many try to get away from the real problems that the society faces. And later, emphasis was made on the art of understanding another language, the text written by some other people in some other languages. And here we have two facets. First, the objective, grammar and lexics, and the subjective, or the psychological component of interpretation. Thus, the hermeneutic circle construct appears, and it's become quite common for proponents for Western jurisprudence, but it is not clear here. Any part of the legal text should be interpreted in view of the entire core of law. On the other hand, the entire core of law exercises its influence on every component part, and hence the idea of this textual approach. And another idea is the interpretation in law should be understood as merging of two horizons. We are trying to merge the horizon, so to speak, of the author who wrote the text and the horizon of the interpreter. And thus we arrive at the discussion about the criteria of interpretation. And quality depends on different factors: the text or its quality and its clarity, and on the other hand, the clarity of the interpretative process itself. A bad text will never lead to an interpretation of good quality. Only if the two components are combined, we reach the maximum effect. And another interesting issue with interpretation is whether should all rules be subject to interpretation, or only those rules that appear to be unclear. There are certain criteria, because some rules are better understandable, some are worse understandable. But the criterion itself depends upon professionalism and qualification, because one interpreter may say that a certain rule is unclear, and the other one will say it's fully clear. Therefore, one should be able to approach interpretation of any rule from the point of view of the entire system of such rules. By alleging that all rules should be interpreted from this viewpoint.
And here I would agree with Ms. Denishevska that text, including legal text, are not always mono-semantic. And we know that from the moment the law is written, we ask ourselves how to understand it. Some people can understand it in one way and others in another. So the entire set of legislation, including the Constitution, are open to interpretation. And that is an issue, and that is a challenge. Now coming to the judicial interpretation, I here agree with Ms. Denishevska in that from the current perspective, the perspective of today, whereby circumstances change, we see this principle of maximum principle openness. And the judge should not only apply the law, but also participate in interpreting it, thus developing the law. It is not actually direct lawmaking, but it is indirect lawmaking of sorts. And I would quote from Leveling again, the final full stop in what the law is and what the law isn't is put by the judges, particularly by justices of appellate courts, Supreme Courts, constitutional courts, and the level of discretion and the level of judicial responsibility is going up. Another thing I would like to draw your attention to, and that's what we usually discuss together with the justices of the Constitutional Court, is what is the subject matter of interpretation from the point of view of tradition is the will of the legislator. And that would be the positivistic tendency. When we are trying to interpret what the legislator wanted to say, it's a shady ground. As Ms. Denishevska says, we never know what other people mean or think. So we should interpret the norms. And the sound is poor again. But nonetheless, the norm should be interpreted rather than the will of the legislator. And given that my time is up, I would sympathize with Mr. Holovate as the mediator. I would say that the judicial bodies, first of all, justices of the second and third instance courts should proactively interpret the law so that to promote the principles of the rule of law, which is much broader than the role of the judges. And I am sure that the judicial body's role will grow in the future. Thank you very much, Mr. Petrician, for your academic perspective of this issue of conflict of interpretation. Unfortunately, we cannot continue the discussion that Mr. Academician Petrician launched. We lack time for that, but I would like to thank all of the speakers, those who spoke in the welcome session and in panel 1. I hope we will have some more time for Q&As and open discussion during the day. Now we have, say, 16 minutes for a break, and then we will reconvene at noon Kiev time. Thank you.
Скажіть мені, будь ласка, де у нас, де кому?
Так вот это же вот это вот.
Да. А украинскую нет?
Я его сделала, не я, Google. Google его сделал. Если хотите, так моя очередь все равно будет. Я могу его зачитать из Google, если хотите.
Ну, смотрите.
Моя очередь, если я
А,
начала.
кстати, вот это вот вы проверяли модель Кельзана?
Нет.
Потому что, может быть, это кельсианская модель.
Кейнсианская?
Келли.
Нет, там же
Нет,
должен
нет,
быть
нет, ну,
Кейнс.
тут же, да. Могла быть
Да.
H5. Думаете?
Что Кейнс разные Кейнс вообще.
Нет. Кельсианская.
Кельсиан.
Кейнсианская. Есть какая-то была еще Келли.
Кельсианская модель. Ну, давайте в гугле
А
посмотрим.
посмотрите, у вас есть доступ? Да?
Ну, то
Посмотрите.
есть через эти самые у вас тоже есть, через 4G. -то.
У меня 4G здесь, наверное, я не умею.
Включить 4G вы умеете? Ну, как это?
Я телефоном не пользуюсь.
Мобильные данные вы включаете и работаете в 4G.
Я в телефоне не могу, не вижу.
А так попробуйте на Горкинг, если вы
Горкинг
умеете.
не берет.
Да, да.
Деревянно.
Как дерево.
Да давай тут кофе. Там же сейчас будет. Там уже 5 человек.
Так, что я
Есть
хотела, что
модель
посмотреть?
Кельсона. Кельсон.
Да, чистое учение господина Кельзена о праве государства.
Есть, да?
Да.
А ну,
Ганс Кельзен. Ну, корень заплакал, конечно.
Сержантский долго жаловался.
Да, не, он как-то звонил, звал, но потом оно отменилось, потому что не было иностранных самых, звал на такую же зумовскую и говорит, я вас научу, как меняться ролями и прочее. То есть я так поняла, что он зумов соображает. Там есть такая группа молодых переводчиков в Фейсбуке, называется RSI Warriors. Вот. Ну, инициаторами беседы, конечно, ну, там очень активно кто еще. Девушка. Даже не столько Аня, сколько вот Ася часто там. И такая еще есть какая-то. Светленькая такая, я с ней никогда не работала. Обменивается активно прям.
Замість цього.
Якщо буде Василь, сідай на сюди. Лишати вас.
Ну, щоб так було. Доброго дня, шановні члени, шановні учасники конференції. Ми продовжуємо нашу роботу. Тема нашої другої панелі – це об'єкти тлумачення в конституційному провадженні за конституційними поданнями, конституційними зверненнями та конституційними скаргами. Перш за все нагадаю, що має кожен з доповідачів і учасників дискусії виступати в межах 10 хвилин. І хочу представити учасників. Доповідачами є Крістос Жакупомолос, відомий фахівець правознавець, відомий фахівець в галузі міжнародного і європейського права, обіймав посаду директора Генерального директорату з прав людини та верховенства права Ради Європи, має величезний досвід і нам буде дуже цікаво його бачення цієї проблеми. Також доповідачем є Ольга Совгиря.
His perspective. Then we also have with us Mr. Olga Sobgira, permanent representative of the Verkhovna Rada of Ukraine to the Constitutional Court of Ukraine, and she represents a happy combination of theoretical and practical knowledge, and she works with us on a permanent basis. She is Deputy Head of the Parliamentary Committee on Legal Policy, Head of the Subcommittee on Political Reform and Constitutional Law. And we will also have with us Mr. Shemshuchenko, who is a Doctor of Law, Professor, and he is academician of the National Academy of Sciences of Ukraine and also academician of the Academy of Legal Science of Ukraine. He chairs the Institute of Law and State. With us is also a member of Parliament of Ukraine, head of the Parliamentary Committee on Legal Policy, Mr. Andriy Kostin. He is the attorney by background, and he has been an MP for some time now. So now I will give the floor to Mr. Christos Giacoumopoulos, a non-consummate expert in the area of human rights. And he represents the Council of Europe. The floor is yours.
Thank you very much, dear President of the Constitutional Court, dear Vice President of the Constitutional Court, dear President of the Venice Commission, dear Madam Denishevska, President of the Supreme Court, esteemed judges, ladies and gentlemen, dear friends. Thank you very much. It's a great honor for me to be part of this distinguished panel about the jurisprudence of the Constitutional Court of Ukraine. My topic relates to the rights and freedoms under the European Convention of Human Rights, achievements and prospects, and I will focus on three main points. First, the crucial role of the Constitutional Court in giving effect to the European Convention of Human Rights domestically, but also, and this will be my second point, the very valuable role in establishing the measures which are needed for the execution of the European Court of Human Rights judgments and establishing, clearing up, I would say, the constitutional foundations for execution measures. And then I will describe, this will be the third point, and conclude with some fundamental future concerns that the court might be faced with to perform its crucial role. So to begin with, let me again say that it is a real pleasure for me to speak to you on the occasion of the 24th anniversary of the adoption of the Constitution of Ukraine and of the 30th anniversary of the Venice Commission. The Constitutional Court and the Venice Commission, and I'm sure that the Vice President of the Constitutional Court and the President of the Venice Commission know that very well, have a very fruitful, long history of constructive cooperation. There are strong institutional, perhaps also interpersonal, I would say, links between us. And as I mentioned before, a long history of cooperation and reaction. In 1996 already, the Venice Commission adopted one of its first opinions with regard to Ukraine on the draft constitution of Ukraine, where the Commission welcomed the creation of the Constitutional Court, stating that this corresponded fully to the prevailing practice in new democracies to protect the constitutionality of their own legal order by a specific independent judicial body. But the interaction between the Constitutional Court and the Venice Commission continued throughout the years with very important legal opinions. For instance, the one, I'm sure that Serhiy will remember it, concerning the capital punishment in 1996, 1999, but also most recently via the adopted Venice Commission amicus curiae brief on the separate appeal against rulings on preventive measures, deprivation of liberty of first instance court, which was examined by the Venice Commission upon request of the Constitutional Court of Ukraine. I would say the Constitutional Court of Ukraine has also a long history of cooperation with other parts of the Council of Europe too. First of all, the European Court of Human Rights, and the presence of Arman Harutyunyan in this meeting is the evidence of this. But I would say that the Constitutional Court has developed very important partnerships with other parts of the Council of Europe too. It became a true and valuable partner for the Council of Europe because through its constitutional practice, it developed the confirmation of the core values of the Council of Europe: human rights, democracy, the rule of law, in a number of areas, not less in the areas of social rights under the European Social Charter. So we can confirm that the Constitutional Court is an extremely important partner. And we understand also that this has not always been a very easy task for the Constitutional Court, as from the very beginning of its operations in 1996, many changes have occurred in the legal setting within which it operates, the constitutional legal space of Ukraine, because plenty of changes have been introduced in the constitutional fundamental laws, but also the Council of Europe machinery has changed. The court, the case law of the court, the positions of the Venice Commission are constantly evolving. Notwithstanding this environment of constant political, social, economic changes, the mission of the Constitutional Court, protecting human rights as the highest social value within the Ukrainian state, as said in the Article 3 of the Constitution of Ukraine, remained absolutely central to its operations and in practice. And we can, I think, unequivocally confirm that the Constitutional Court became a very trustworthy partner for the Council of Europe. I think that this is also due not only to its interpretation of the international legal obligations of Ukraine, but to some extent to the innovative approach of an attempt to synchronize this synchronization approach of the case law of the Strasbourg Court with significant steps which are taken by the Constitutional Court of Ukraine through its judgments, decisions, to become somehow the domestic facilitator of work of the Ukrainian authorities in executing judgments of the European Court of Human Rights. And I would like to give some examples in this respect, because I think that they are absolutely remarkable. The Committee of Ministers of the Council of Europe, as you know, is not only the chief executive body organization, but also under the European Convention of Human Rights. It is also a monitoring body which deals with the monitors the execution of judgments of the European Court. I will refer to some issues. First, the declaration of the unconstitutionality of the decree of the Presidium of the Supreme Soviet of the USSR of 1988 on the procedure for organizing and holding meetings, rallies, marches, and demonstrations. I referred to the Constitutional Court's judgment of 8 September 2016, and to the fact that the Committee of Ministers declared this judgment an important step at the domestic level with a view to adoption of legislation necessary to fill the legislative gap, the lacuna, identified by the European Court of Human Rights in the case of Yerenzov. Another example, the declaration of unconstitutionality of the provisions of the Code of Criminal Procedure as regards the automatic extension of detention on remand without court order between the end of the investigation and the beginning of the trial. This was the Chanev-Ignatov group of cases, and the Constitutional Court adopted the judgment in 2017. Then one more example, in the case of Shvitka versus Ukraine, concerning a violation of Article 2 of Protocol number 7 to the Convention. The Constitutional, upon a complaint by the Commissioner on Human Rights, the Constitutional Court took a position, a judgment, which facilitated the execution of this judgment. Now, in addition to the above, we have witnessed, I would say, constant progress in the implementation of judgments of the Strasbourg Court in areas also which are particularly delicate, like as the judicial reform of Ukraine, issues of independence, efficiency, access to justice, but also in respect of the non-execution of judgments. You know that we have this important group of cases, the failure to ensure access to justice because of the non-execution of judgments. This is the famous Ivanov-Burmich group of cases. And the Committee of Ministers welcomed the adoption of the judgment of 15 May 2019 of the Constitutional Court, declaring unconstitutional the obligation to pay an advance fee for the enforcement of judgments against the state. So it established a constitutional foundation for the transformation of the system of enforcement against the state in Ukraine. The Constitutional Court de facto, in this way, cemented the legal foundation for framing the process of execution of these complex judgments, in ensuring the necessary constitutional support to the efforts of Ukraine to find the appropriate solutions to this long-standing problem. I think that the issue will also be perhaps addressed by Mr. Costin, who is present here. I think it would be important to have an exchange on this topic. Now, in addition to the judicial reforms concerning the non-enforcement issue, there are a number of other aspects. I will refer specifically to the judgment of the Constitutional Court declaring unconstitutional Article 375 of the Criminal Code as constituting a threat to judicial independence. In fact, such a repeal was clearly requested by the Committee of Ministers in March 2020, when the committee considered the case of Alexander Volkov, the Volkov group of cases, was not only one, where we can see that the call of the committee called the authorities to undertake a comprehensive revision of the criminal law provisions concerning the liability of judges, with a view to eliminating the continuous threat posed to judicial independence by the vague wording of Article 375 of the Criminal Code, either by fully revising it or abrogating this position. We believe that this was clearly heard by the Constitutional Court. In some exceptionally complex legal situations, the Constitutional Court may find itself that the interpretation of the European Convention of Human Rights provision by the European Court of Human Rights may differ or collide, perhaps, contradict domestic constitution. This is possible. It happens. It may happen. But such a finding would not remove practically the obligation under Article 46 of the Convention to abide by the judgment rendered against it. In these extreme cases, the possibility of amending the constitution could be envisaged. It has already happened in the situation of Ukraine with some execution measures in the case of Volkov. But what we have to conclude is that the role of the Constitutional Court should be to identify a possible constitutional obstacle, if any, and of course suggest possible ways to overcome it. Now, let me come to the future challenges, and I will end my presentation there. One of these is the introduction of the right to individual constitutional petition. This mechanism proved to be extremely vital for the implementation of the European Convention of Human Rights domestically. Some states that had long-standing problems with domestic remedies, and compliance with the European Convention of Human Rights, and an excessive number of cases, have found a solution through this system. Turkey, for instance, the Constitutional Court, after the introduction of the right to individual petition, is now the Constitutional Court, the right to constitutional petition is seen as a effective domestic remedy before application to the European Court. And this allowed the Constitutional Court of Turkey to become a real partner and have a real dialogue with the Strasbourg Court. The domestic legal system has, through this individual petition system, can acquire a very strong potential of securing effective exercise of human rights enshrined in the convention. Another challenge is the dialogue with the European Court through Protocol 16 to the convention. We understand that the Constitutional Court is not part of the institutions allowed to bring requests for advisory opinions, but this perhaps should be reviewed on the basis of the development of the individual petition to the Constitutional Court. The protocol remains an extremely useful tool, and we are awaiting its entry into force with respect to Ukraine. I hope that the issue of which judicial body can address the European Court of Human Rights shall be resolved rapidly. The legislative grounds for an involvement of the Constitutional Court in this dialogue should be reconsidered, reassessed in view particularly of the individual application. So in order to close my presentation, first and foremost, we need to, I think that it is important for the Constitutional Court to continue this synchronization of case law with the case of its own case law, with the jurisprudence of the European Court of Human Rights. One can see that Ukraine has a legal system with a somewhat limited possibilities of reception of international law on the basis of Article 8, 9, and perhaps 55 of the Constitution. I'm sure that Pavlo Pușcar will speak more about that. It has somehow a complex system of recognizing case law of the court as part of the formal constitutional law sources. But I leave that for Pablo to engage further. The next logical step to be taken, building upon the legal doctrine already formed in the Constitutional Court's case law of the legal doctrine of a friendly attitude to international law and to the requirement to take into account the interpretation of the convention by the Strasbourg Court and the case law of the Strasbourg Court. The next step, therefore, is the firm recognition of the case law of Strasbourg as part of the constitutional case law on human rights for Europe. And this is would be logical because the European Convention of Human Rights is not just an international treaty. It is really, as the court has had an opportunity to say, it is a constitutional instrument of the European public order. And this was so, taking that into account would be a positive step. The role of the Constitutional Court of Ukraine is absolutely crucial, and I can only congratulate the court for its achievements. I can assure you, by the way, that in the Council of Europe, as a whole, but in particular, I would say the Directorate General of Human Rights and Rule of Law, the Venice Commission, and other institutions that we serve as a Directorate General, you will find trustworthy experts who can support your important work, but also friends and colleagues, and I'm underlining the term friends of colleagues, with whom you can rely, who understand the challenges you are faced with and the tremendous work that you do for the implementation of human rights in Ukraine. So hard work for sure. I'm fully confident that your court will be able to nurture its own success and build upon these successes, aiming for future achievements. And I'm looking forward to our future exchanges. Myself and my colleagues remain at your disposal. Thank you very much.
Я дуже дякую пану Крістасу Жакому.
Thanks very much, Mr. Giacomopoulos, for your very insightful and interesting speech. No doubt that it deepens our perception of the existing issues and will enable reassessing our approaches to the search of solutions. And now let me give the floor to Olga Serhiy, professor and parliament member of Ukraine, permanent representative of the Verkhovna Rada, the Constitutional Court. Good afternoon. I'm very glad to see you. I want to focus my talk on something very important for the Constitutional Court and equally important for those subjects that appeal to the Constitutional Court. Specifically, I want to speak about analysis of the constitutional actions in terms of their soundness. I will speak about the existing practices, and I will mention some of the tendencies in a number of foreign countries regarding assessment of the good grounds for lodging constitutional actions. Some of the issues that exist are seen because of the shortcomings in the text. Sometimes allegations of those who lodge actions really make mistakes, and abuse is a third issue. What are the so let me suggest a definition. Very often those who lodge actions fail to explain what they are after, and they just quote the laws of Ukraine or the judgments of the constitutional courts or the judgments of the European Court of Human Rights without indicating what they specifically challenge. And I want to analyze some of the petitions that came to the Constitutional Court between January and June of this year. Analysis of these petitions made it possible to see that in most of them, subjects allege to violation of the principle of rule of law with regard to the meaning of the laws they challenge or the procedure of their adoption. They specifically indicate violations of the procedure of registration of laws or of their coming into effect, or nor the lack of the aim of regulation. or failure to make amendments to other laws, or violation of the competences of different authorities, or violations or abrasions of human rights and freedoms. We analyze the practice, the case law of the Constitutional Court in terms of the grounds it furnished when it dismissed constitutional petitions. And we can see that the Constitutional Court has already developed some groups of criteria in compliance with which the any petition is to be analyzed, and I will mention some of the tendencies that we managed to identify. The Constitutional Court focuses attention on the fact that subjects are to explain their allegations regarding unconstitutionality of a certain legal act. They are to refer to the specific provisions of the Constitution that, as they allege, were violated with the adoption of a certain law or of its article. The Constitutional Court said that allegations of the authors regarding possible collision or disbalances of the bodies of authorities is just a presumption, while presumptions or allegations cannot be mean arguments supporting the thesis of unconstitutionality of a certain legal act. Another group of arguments mentioned by the Constitutional Court as a set of criteria is that specific legally established facts should be referred to and not some abstract data or general information. The third thing to be aware of is that in the constitutional action where a procedure or the procedure violation is referred to, this may not serve as the criterion of admissibility of a constitutionality action. A breach of the procedure per se cannot act as a sound reason in this respect. Others claim that it is impossible to consider any presumptions of the kind of that refer to some abstract social relations. Such allegations cannot be deemed proper for a constitutionality action. The Constitutional Court also says that comparing current laws and the preceding laws cannot serve as grounds for a constitutionality action, even in the instances of narrowing of the rights of some subjects, with the exception of the rights envisaged in Article 64 of the Constitution. Could you please speak more slowly? Well, may I also stress that recently, thanks to the Constitutional Court of Ukraine, in this nation, the doctrine of the rule of law is very actively developing, and the constitutional actions that come to the European Court often refer to alleged violations of the principle of rule of law. Therefore, time is ripe to identify how to understand the principle of rule of law in the aspect of admissibility and in the aspect of motivations within constitutional actions. What do I mean? Well, sometimes it occurs that the principle of rule of law is too extensively applied by the subjects with some manipulations. We decided to study relevant foreign experience with regard to understanding of the essence of the principle of rule of law. Specifically, we refer to the experience of Germany, and I want to share some of our findings. As regards how the Germans motivate the possibility of constitutionality action. Such an action as a petition is admissible only if the subject alleges that there was a mission of authority on the part of a body, or there was a threat or a risk of possible violation of a human right. As for the possible incompliance of laws with the Constitution, federal or land, it is 1/4 of the Bundestag that can apply, and the criteria of admissibility are such that if the subject believes that a law is incompatible with another federal law, or if the subject refers to a law as per which a court earlier refused to apply it because this law was deemed unconstitutional or incompatible with it. Or if the subject of the Constitution believes that a certain legal act does not comply with the competences of the federal authorities in making their decision. What does it all mean? The principal idea is that a constitutionality action may be submitted only with regard to violations of specific provisions of the Constitution, which are implemented in practice and real life. It is also specified that in a number of works about Germany, the declarative norms of the Constitution may not serve as the basis for the position expressed in the text of the constitutionality action. In other words, there is again to be a reference to a violation of a specific stipulation and not of a general principle. Principles are guidelines for the development of the political strategy of the state, for the policies of the lawmakers to identify the principal directions to be reflected in the national legislation. And as for a coordination of these principles with human rights, the construction of the Constitution matters. In foreign literature, and specifically in Germany, we don't see any direct relationships with the above-mentioned factors, and therefore at stake are not any real rights that emerge. And if we look at the Ukrainian realities, there are so many references just to the principle of rule of law, which often takes place in a number of constitutionality actions. And in Germany, that would never be deemed sufficient in order to challenge constitutionality of a certain law or regulation. So I call on the Constitutional Court and on all academics to further discussions in this area. We are well aware of the problem that exists in Ukraine and which I highlighted, and the Constitutional Court of Ukraine has to develop a concept and the regular tendencies in order to enable others to understand the full scope of the principle of rule of law and what should be indicated in all actions regarding constitutionality. And let me also say that backstage in the parliament, sometimes we hear conversations about some constitutionality actions, which prompt that some subjects are abusing their right to request the constitutional court, and that some may even want to challenge renaming of villages. Yes, the analysis of the recent actions lodged with the Constitutional Court testifies to a very particular and peculiar understanding of the constitutional provisions by some subjects. That's all. Thank you. Thank you, Olga Sovkira, for your insightful presentation. And Professor Grinyuk has a question whether it is appropriate to interpret laws of Ukraine. What would you say? Well, I think that today we see that the Constitutional Court of Ukraine is overburdened, and very largely it is explained by the fact that in the legislation there is no clear-cut criteria which would allow dismissing constitutionality actions which are ill-grounded, as well as some politically motivated actions. If the Constitutional Court is given the authority to interpret laws, the number of actions and petitions incoming will increase drastically. It's the parliament that adopts laws. So from the political point of view, it would be good if the parliament could explain what it meant when it passed a certain law. Well, thank you all. And what about the function of the official interpretation of constitutional norm? Is it possible in the motivation to refer to the constitutional writs? While comparative law is one of the methodologies helping to identify the real lining of every constitutional norm. However, no two states are identical in terms of their histories, political systems, legislations, or other conditions. On the other hand, there may be questions regarding the views of some judges regarding, for example, widening or the narrowing of the authority of the parliament or of other bodies that have taken place in a number of countries. Well, that's the political process, which is more dynamic in some nations than in other countries. So to say that the Constitutional Court and some constitutional justice does not depend on politics would not be true, because the Constitutional Court is always to assess the political factors too, to a certain extent. Thanks very much for your answers. And now I'm giving the floor to Yuri Shemshuchenko, professor, member of the National Academy of Sciences, member of the Academy of the Law Sciences of Ukraine, director of the Institute of Law and Statehood of the Academy of Sciences. Good afternoon, dear participants. Welcome. this conference. As for the issues that we are discussing today, I would like to concentrate on two. On the development of constitutionalism in Ukraine, and on the development of the case law of the Constitutional Court, as well as on the place of the constitutional justice within the Ukrainian system of justice. Посмотрите звуком. Interpreters have problems hearing the speakers, sorry. Юрочка, ви чуєте його?
Constitutional and legislative reforms have of great value, are of great value to our country, but those reforms are insufficient, or they are insufficiently implemented, and thus we cannot see the practical results. And these reforms affecting law and legislation are haphazard and are not of a systemic nature. It pertains in particular to judicial reform, which has been in place for decades, since 1999, and we still see no completion in the near future. So the problem is the theoretical background against which and the basis on which those reforms are being implemented. So we've got a lot of law theoreticians, those who specialize in constitutional law. Over the last few years, thousands of publications and research papers have been issued. A whole series of manuals in the area of constitutional law have appeared of late, etc. And the Constitutional Court has a special consultative board, expert consultative board, which I hope will contribute to the increased efficiency of the Constitutional Court. All of that is true, but we have heard a lot of proposals by the constitutional law scholars that will never be translated in practical steps. And I believe that the major issue here is that the state does not timely formulate the order, the demand for the development of well thought of laws and other legal acts. Here I would like to refer to a German poet, Goethe. You might not know that, you all know him as a poet, but few know that he was also a lawyer. And he carried out a lot of research in the area of law. And back then, he identified certain issues that are still topical today. And he said that the woe of the legal science, of the legal research, is not that it fails to provide certain well-established recommendations, but the woe is that practitioners fail to implement those recommendations. And the practitioners cannot actually formulate this order for the theoretician, for the legal scholars to take on and develop further. So perhaps that's our problem as well. And I can add that the theoretical or research findings that we have already got fail to be implemented in practice. In this context, our institute has approached several public agencies and institutions, encouraging them for cooperation and for arranging certain fora where theoreticians can meet practitioners and discuss their more effective and efficient interaction. Particularly in terms of defining our strategy and steps towards its implementation. So that we know exactly what kind of republic, what kind of the state we are going to create presidential, parliamentary, presidential, law-guided or rule-guided country, etc. So I believe that this dialogue between theoreticians, scholars, and legal professionals will be extremely useful. And this issue is closely related to the expert examination of legal acts. Here I mean not even the expert examination per se, because we have a lot of achievements there. What I mean is the legal law examination as a way of doctrinal interpretation of legislation. This has become possible thanks to the engagement of researchers, theoreticians from our institute to this process. Of course, we need to train such experts who will be working in such expert boards and commissions. The use of the findings of research expert examination is one of the very important ways to ensure the proper implementation of the Constitution and protection of rights and freedoms. Sorry, we cannot hear the speaker. I'm very sorry. The law on research and technological expert examination can come in handy in promoting this type of examination. The experts could be natural persons with high qualifications and specialized knowledge, as well as specially established expert organizations or groups. Such as, for example, the one operating under the Institute of the Law and State of the National Academy of Legal Sciences of Ukraine. We've accumulated a very rich body of experience and knowledge since our establishment in 2002, and we can offer expert examination of laws and other acts of legislation. We pronounce 160 to 170 expert opinions for various organizations and institutions. We also cooperate with the Constitutional Court and offer our expert examinations to them on request. We work with other judicial and executive authorities. In 2018, our experts prepared and sent to the counterpart 9, and in 2019 such opinions. Since January this year, we've developed 6 opinions on the application of constitutional law. Mr. Shimshichenko, you have used all of your time, I'm afraid. Yes, thank you. I understand that. Just to end, I would like to note that legal expert examinations are always in the focus of attention of our institute, and it is extremely important for the experts to cooperate closely and meaningfully with the institutions seeking such examination. And finally, the criterion for the operation of any public authority, including the Constitutional Court of Ukraine, is the promotion and protection of human rights. So I understand that the repeal of the norm of the Constitution on the right of prosecutorial bodies to present represent the interest of Ukrainian citizens in court runs counter to Article 3 of the Constitution of Ukraine, according to which human health and life is the utmost social value of this state. So let us be guided by the Constitution in our everyday life. Thank you very much for your attention. Thank you, Mr. Shimshichenko.
Mr. Shimshichenko. Each of the issues that you mentioned could be covered by a separate conference. And now let me give the floor to Andrei Kostin, professional lawyer, member of the Ukrainian parliament, head of the committee for legal
Дякую дуже за
policy.
запрошення і, користуючись
Thanks very much for the
нагодою, хочу
invitation. Let me avail of the
привітати всіх
opportunity
з
to
24-ю річницею
congratulate everyone on the
прийняття
24th
Конституції України.
anniversary of the adoption of
Хочу
the
також
Constitution of
приєднатися до
Ukraine.
привітань щодо 30-річчя
I
діяльності
also congratulate
Венеційської
everybody on
комісії,
occasion of the
яке
30th anniversary of the
відбулося в
Venice
травні
Commission.
цього року, і подякувати
That
колегам
anniversary was
з
marked
Венеційської
in
комісії
May,
за
and
ту
I thank
підтримку,
our
яку
colleagues from the
вони
Venice
надають
Commission
Україні, українському народу на
the
протязі
support they've been
всієї
giving to
своєї
the
діяльності.
Ukrainian people
Ми знаходимося в контакті і як прямому, так і через інші інституції Ради Європи, і це дуже важливо. Хочу також привітати всіх з 30-річчям. Ми також святкуємо в цьому році 30-річчя Декларації про державний суверенітет України. І в цієї нагоди відбудеться урочисте засідання Верховної Ради України. І знаєте, я, повертаючись до цих багатьох засадничих рішень наших колег в українському парламенті 16 липня 1990 року, просто хотів би зацитувати і нагадати дещо, в тому числі в декларації зазначено, що вона є основою для нової Конституції України. Тому цей, ви знаєте, цей зв'язок є дуже важливим, тому що ми всі з вами пам'ятаємо, що 1990 рік – це ще рік існування Радянського Союзу, і дуже важливо, що наші колеги вже тоді розуміли необхідність прийняття, розробки і прийняття нової Конституції, за якою ми всі, і український народ, живемо і працюємо зараз. В цій ж декларації є також декілька принципів про те, що Україна визнає перевагу загальнолюдських цінностей над класовими і пріоритет загальновизнаних норм міжнародного права перед нормами внутрішнього державного права. Ну і дуже важливим є також те, що в розділі 3 цієї ж декларації визначено, що державна влада в республіці, ну тоді ще була Українська РСР, здійснюється за принципом її розподілу на законодавчу, виконавчу і судову. І цей розподіл, який є засадничим для існування будь-якої демократичної країни, але цей розподіл не виключає взаємодію між гілками влади, і він передбачає також і комунікацію між всіма гілками влади, тому що всі гілки влади, незважаючи на власну автономність, вони несуть таку спільну солідарну відповідальність перед суспільством українським за все, що відбувається в країні, за всі успіхи і за всі поразки. Тому питання комунікації між гілками влади, між судовою, законодавчою, виконавчою, в тому числі комунікація на рівні Конституційного суду, є дуже важливим для того, щоб ті закони, які приймаються Верховною Радою, вони не тільки відповідали засадам Конституції, але і відповідали тим очікуванням, яке має суспільство в відносинах суспільних, які зараз так стрімко розвиваються. Ми з вами живемо в час, коли дуже швидко проходять якісь зміни в суспільстві, і це є викликом, в тому числі і для законодавчої влади, в тому сенсі, що деякі питання потребують законодавчого врегулювання частіше, ніж це відбувалося, наприклад, 10 чи 15 чи 20 років тому. І це є викликом, в якому ми всі повинні знаходити баланс між тим, чи потрібно саме зараз щось регулювати, чи є це настільки актуальним і пріоритетним, щоб це робити саме зараз, або все ж таки взяти час для того, щоб в режимі такого, ви знаєте, широкого обговорення деякі питання приймалися в розумний строк. І розумність цього строку в підготовці нормативних актів для прийняття Верховною Радою є також балансом, який ми відшукуємо кожного разу, і це відбувається все одно це відбувається, і це дуже правильно в комунікації з іншими гілками влади. Так, абсолютно зрозуміло, що ця взаємодія між нами всіма, вона проходить в такий в такому звичайному режимі, і я тут скажу таку дуже цікаву річ. Я працював 24 роки адвокатом і займав вибірні посади в органах адвокатського самоврядування і представляв українську адвокатуру в кількох міжнародних організаціях і на рівні CCBE, і на рівні Міжнародної асоціації юристів. І ви знаєте, багато виступав перед молодими адвокатами, і часто як відбувається, якщо якісь суспільні відносини регулюються відповідним законом, то здебільшого, і ми цього очікуємо, дуже би хотіли, щоб саме виконавча влада, яка працює, так скажемо, на землі з людьми, і яка збирає всі ті проблеми, які існують в країні, і які не можна врегулювати на рівні актів виконавчої влади, все ж таки виконавча влада була основним постачальником законопроєктів до парламенту. Це нормальна практика, яка передбачає, по-перше, аналіз проблем, які існують в суспільстві, і підготовку на експертному рівні, яким володіє, повинна володіти саме виконавча влада, відповідних законопроєктів, і далі їх голосування вже на рівні Верховної Ради. Але так відбувається, що між виявленням цієї проблематики, між її аналізом, підготовкою пропозицій, все ж таки триває деякий час, і цей час може бути достатньо довгим. І в цей період саме судова влада, вона зазвичай, так скажемо, допомагає суспільству в такому файн-тюнінгу, тобто в додатковому регулюванні того, що вже на рівні закону неможливо врегулювати. І саме в такий спосіб з'являється судова практика, яка дозволяє дещо змінити деякі підходи або врегулювати те, що поза межами опинилися норм закону. І саме ця судова практика, яка до створення якої мають відношення як адвокати, і це дуже важливим, тому що саме адвокати, вони є тим драйвером, який може впевнити, аргументувати суду по конкретній справі, що треба врегулювати додатково для того, щоб система працювала в загальнодержавному сенсі. І цю практику українські адвокати, як і адвокати будь-якої іншої країни, вони опираються на багаторічний досвід роботи адвокатів саме в Європейському суді з прав людини. І ми пам'ятаємо і знаємо з вами, скільки правових конструкцій вироблено практикою Європейського суду з прав людини. І за кожною з цієї конструкції стоїть не тільки робота суддів, яку ми дуже поважаємо, але й першочергово це позиція адвокатів, які є все ж таки представниками в широкому сенсі звичайного громадянина, права якого требують якогось відновлення або захисту на судовому рівні. І ця судова практика, коли вона накопичується і становиться такою, є такою критичною, вона також спонукає законодавця приймати відповідні зміни і врегулювати закон таким чином, щоб він відповідав суспільним відносинам, які існують на даний момент в країні. Я про це говорю, тому що те, що нам потрібно зараз, і ми будемо намагатися це зробити в найкращий спосіб, це комунікація, взаємна повага і взаємна допомога між всіма гілками влади для того, щоб ми
виходили на якесь рішення, яке
достатньо і правильно регулює суспільні відносини, для того, щоб це рішення приводило до позитивних наслідків, і ці позитивні наслідки були на користь суспільства в широкому сенсі. Та, безумовно, коли збирається багато юристів, буває дещо складно дійти консенсусу з тієї чи іншої точки зору. І в цьому сенсі є дуже важливим якраз допомога експертна, яку ми отримуємо як від міжнародних інституцій, так і зараз у нас є представники Венеційської комісії, як я вже зазначив, у нас є представники Ради Європи, і це дуже важливим для того, щоб з принципових питань формувалася така позиція, яка буде відповідати не тільки очікуванням українського суспільства, буде відповідати загально визначеним нормам міжнародного права. І здебільшого загально визначені засади європейського права, вони відповідають і конституційним засадам, які відтворені в українській конституції. Тому весь цей все це коло питань, вони є дуже пов'язаним взаємно, і ми будемо намагатися в такому діалозі відкритому знаходити баланс як часовий, так і баланс в прийнятті тих рішень, які потребують свого регулювання. Я б хотів також зазначити і окремо подякувати пану Кристосу Джакомополосу за те, що він і пану Павлу Пушкарю, з яким ми, в принципі, в такій щотижневій комунікації або іноді щоденній комунікації для вирішення тих питань, які постають перед комітетом і парламентом, подякувати за ту допомогу, яку вони надають з точки зору приведення українського законодавства у відповідність з практикою Європейського суду з прав людини і з Європейською конвенцією з захисту прав і основоположних свобод. І це є дуже важливим, тому що, на жаль, деякі законодавчі акти, які приймаються, вони проходять деякий час, і ми розуміємо, що на рівні Європейського суду з прав людини приймається рішення, яке визнає порушення Україною як державою деяких положень Європейської конвенції з прав людини. Але, на жаль, це на щастя, це інше питання, але це зазвичай це відбувається з таким достатньо довгим лагом в часу. Тобто є розуміння того, що, мабуть, на час прийняття відповідного закону він вже приймався в невідповідності з практикою Європейського суду з прав людини. Але з урахуванням процедури розгляду справ в Європейському суді, проходить кілька років, буває, коли приймається рішення. І це означає, що цей закон, який працював, він деякий час складалася ситуація, коли в українському законодавчому полі існував закон, який не відповідав нормам Європейської конвенції. І це дуже сумно. Я думаю, що, мабуть, вкрай складно це просто припинити, але наше завдання – це зменшити таку кількість нормативних актів, які потім на рівні Європейського суду з прав людини визнаються такими, що порушують Європейську конвенцію. Тому ми підтримуємо на рівні Комітету з питань правової політики діяльність підкомітету з питань виконання рішень Європейського суду з прав людини, і дуже вдячні за те, щоб все ж таки впровадити за допомогою наших експертів з Ради Європи систему якогось моніторингу законів України не тільки на відповідність Конституції, що ми робимо в межах своїх можливостей, але й на відповідність практиці Європейського суду з прав людини. Це дозволить нам приймати закони, які будуть відповідати Європейській конвенції, і зменшити кількість тих законів, зменшити кількість в кінцевому окремому випадку рішень Європейського суду з прав людини, в яких встановлюється порушення Україною Європейської конвенції з прав людини. Щодо нашої співпраці з Конституційним судом, вже Ольга Володимирівна дуже багато про це говорила в своєму виступі. Я не буду займати ваш час, просто скажу про те, що ми готові для діалогу, ми знаходимося в діалозі і, звичайно, розуміння того, чи відповідає, чи не відповідає відповідний законопроект Конституції, воно також іноді буває дискусійним, тому що ми всі юристи, і багато юристів в парламенті, вони представляють в тому числі різні політичні сили, і тут знайти баланс між правовою конструкцією та політичною необхідністю або політичною позицією. Не завжди це легко зробити, але ми будемо намагатися це робити все ж таки в найбільш ефективний спосіб. І комунікація, діалог, спілкування і взаємна допомога всіх гілок влади і Конституційного суду, особливо в нашій спільній справі, є дуже важливою. Я хочу всім подякувати за цю можливість поділитися з вами своїм баченням розвитку нашої взаємодії, і маю надію на те, що наш діалог буде більш ефективним, більш активним, і це допоможе нам знаходити спільні думки для того, щоб українські закони і відповідали Конституції, і практиці Європейського суду з прав людини. Дякую всім за цю можливість.
Thank you very much for your very interesting presentation. I want to thank all those who participated in this panel. I thank Christos Giacomopoulos, Director General of the Directorate General of Human Rights and the Rule of Law. I thank Professor Olga Serhiy, permanent representative of the Verkhovna Rada of the Constitutional Court, Member of Parliament. I thank Yuri Shemshchenko, member of the Academy of National Academy of Sciences of Ukraine. I thank Andrei Kostyan, member of Parliament of Ukraine. We now, after all these speeches, have a better understanding of the objects of interpretation in constitutional proceedings, and we break until 2 p.m.
Доброго дня, шановні колеги.
Good afternoon, dear colleagues. I am Alexander Vodyannikov, National Legal Advisor, Head of the Department of the Rule of Law of the OSCE PCU. And it is a great pleasure and a great honor for me to moderate panel 3, subject of interpretation in constitutional proceedings. Bismarck is believed to have said that those who like sausages and respect law should not know the details of generating both. So today we will be speaking about how the interpretation is generated in the constitutional proceedings, and it is my pleasure to introduce you to the speakers. Yuri Barabash, Head of the Research Advisory Council of the Constitutional Court of Ukraine, Doctor of Law, Professor Corresponding Member of the National Academy of Legal Sciences of Ukraine, and Vice Rector of Yaroslav Mudry National Law University. He is well known both in Ukraine and in Europe. Mr. Alexander Tanase, member of the European Commission for Democracy Through Law, Venice Commission, President of the Constitutional Court of the Republic of Moldova, and a person, the expert, who has been nominated to be special advisor to the Constitutional Court of Ukraine. We also have with us, I hope, Mr. Karabekh Dushiev, Chairman of the Constitutional Chamber of the Supreme Court of the Kyrgyz Republic, and he is a very well-known constitutionalist, and Mr. Pavlo Pushkar, Head of Division of the Department for the Execution of Judgments of the European Court of Human Rights, Directorate General of Human Rights and Rule of Law, Council of Europe. So now I will give the floor to Mr. Barabash and remind all of the speakers to please keep within the time limits of 10 minutes. Yuri, being the head of the Research Advisory Council of the Constitutional Court of Ukraine, what role can your council play in actually adhering to the positions of the Constitutional Court? Thank you. I would like to thank Alexander for this opportunity to speak. And I would like to thank all the organizers and Venice Commission for a very fruitful cooperation with Ukraine. The question that you've asked is quite well justified. The Research Advisory Council has been operating for about 6 months, and I would like to discuss the role of the academic doctrine and its role for the interpretation activities of the Constitutional Court. I would also like to greet our friends and partners, Mr. Jalimasa and Alexander Tanasu, who protect Ukraine, though they are not Ukrainians by nationality, but they are Ukrainian in their hearts, I believe. And I will be referring to some of their findings and some of their recommendations, because this doctrine gave rise to very vivid discussion, and this term has been included in Ukrainian textbooks on the history of law. So you will be the founders of the history of Ukrainian law. The interaction between the academia and the Constitutional Court has evolved over years, and is the first actually iteration of the Constitutional Court that decided to seek assistance of the academic institutions. And the Constitutional Court often underscored that this or that academic institution, university or research institution actually supported their opinion. So they either referred to it in general in the introductory part, or they would actually give the name of the expert and saying that they support the position of the constitutional applicant, but they would not go into detail and would not assess certain doctrinal items or ideas. And I will be speaking about that a bit later. The Western constitutional control bodies also are not overexcited when it comes to constitutional doctrines. At the same time, the Constitutional Court invited researchers as experts to pronounce some expert opinions, not as often as today, though. And they would usually be engaged in either oral hearings or written proceedings, and we can only guess today, thanks to the transparency and openness in the activities of constitutional justice bodies, how varied and diverse this range of experts has been. And that was a test for loyalty on the part of some leaders of legal schools. And I believe that the Constitutional Court did correctly when it released this energy that should actually develop in autonomous universities. And now we deal with a true position of Ukrainian academia. Sometimes an attempt to be loyal to everyone, it created very humorous and funny situations. And I have here a press release of one of the academic institutions that responded to the conclusion of the Constitutional Court. And that opinion then gave rise to a lot of discussions in that region, and the university said that they did not pay enough attention to the preparation of that expert opinion, and that was the position of an individual researcher. Moreover, the rector of the university is on the side of the law that is being challenged, and the expert who pronounced the opinion will be subject to investigation. Yeah, that might be funny, but it is actually sad in that it means that we have not yet achieved the level of academic freedom that our neighboring countries can boast. As far as the cooperation with the academia of the Constitutional Court with the academia is concerned, in particular in the large, in the Grand Chamber, sometimes those appeals or those requests for the opinions have two grounds. Sometimes just to explain certain doctrines, and sometimes to prove, with the help of certain researchers, that the judge's position is correct. So that is very well understood, and we understand that the Constitutional Court's business is different from from ordinary courts according to the council's model. And I would tell you about the activities of our council. As I said, it is a very young institution, but we have got the situation whereby the members of the council, in cooperation with reporting judges and with the court in general, are launching a process of interpreting certain doctrinal ideas or issues. And I would refer you to the conclusion, to the opinion of December 2019, and we have with us the reporting judge in this, judge rapporteur in this case, and it was about initiating amendments of the Constitution in terms of actually terminating the powers of the members of Parliament. Several members of the council were engaged in this work, but their ideas were not always very popular, and their opinions and the work of the court and the judge rapporteur said that step by step our constitutional court is forming its own doctrine of constitutional identity. I cannot compare it with the basic structures of the constitution of the Supreme Court of India, for example, or the second doctrine of the replacement of the constitution that was developed by the Constitutional Court of Colombia. But at least I would like to say that it is extremely topical under the ongoing constitutional reform and permanent constitutional reforms that the justices of the Constitutional Court can seek assistance of the council, of the advice council, in forming this constitutional identity. In the case of Colombia, their Constitutional Court stated that despite very little interpretation of the constitution, we should remember that the constitutional order of Colombia leans on democracy and rule of law, and interestingly enough, they used to have Alvaro Uribe as the most popular president, and he was running for president some time ago, and the premise of his campaign was the need to amend the constitution, and with the doctrine of the replacement, with the when he ran for presidency for 2 times, and then he decided to do that for the 3rd time. And I would not here make any references to the situation of 2003. And the Constitutional Court said that the norm allowing him to run again runs counter to the democratic nature and the separation of powers. At the very beginning of my presentation, I referred to the work on official formal constitutional doctrine, and at one of the congresses of a very important organization, BCG, we had a discussion with Professor Rachinsky about the correlation between the official constitutional doctrine and the academic constitutional doctrine. And I would not actually see anything tragic when justices of the Constitutional Court refuse to listen to the opinion of the academia. Foreign constitutional bodies actually do not often invite academicians to support their doctrines, particularly in some Muslim countries, when they engage 4 or 5 professors, none of them being experts on constitutional law, but rather they worked with experts on sociology or pedagogy. I spoke about the specifics of actually establishing the constitutional law, and when we speak with the experts on constitutional law, with the academics in this area, we see that our judges are very well prepared in terms of the theory and practice. And when people complain that justices of the Constitutional Court do not listen very attentively to the opinion of the academia, I perceive it as something very normal, because actually we do not have any polemic research, just we have manuals with collections of legal positions of the court. I understand that we still lack this meaningful interaction. And I understand that we owe it to the Constitutional Court because we don't have anything to offer to them, anything meaningful to offer to them. And here we speak about the situation whereby we don't know what to do with the rulings on certain constitutional complaints, and you will know that situation when the citizen use his right protected by Article 55, and then they go to the courts of general jurisdiction, and they tell him that you are very late. What you did is okay. And in one decisions of the Supreme Court, I came across this. The Supreme Court said it's okay that you've got a ruling by the Constitutional Court, you've achieved certain justice. And here I agree with Mr. Galavati in that the constitutional complaint is not a tool for the sake of the tool. A person or an individual protects their rights in the constitutional court, and they get satisfaction with regard to themselves, but it does not apply to other citizens. So when I started looking for certain theoretical sources or research in this area, I failed to find a lot of materials on this issue. Likewise, we are now celebrating the 24th anniversary of the Constitution, and we've got the article in the Constitution on the damage, awarding of damage, but it does not work. So I think that we have to work hard to actually repay this debt to the Constitutional Court. We have had certain challenges with the lockdown and with the very brief period of operation, but I am sure that I will be able to do that in the future. And Mr. Jalimas is quite correct when he said that oftentimes constitutional doctrine or practical constitutional doctrine is consonant with the academic constitutional doctrine. The role of the Research Advisory Council should not be reduced to just legal opinion, but in fact, there should be mutual insemination or fertilization or enrichment, and the council should actually learn from the Constitutional Court and you will know that in one of the neighboring countries, the dissertation was protected under the name of Doctrines of Constitutional Law, but it failed to actually disclose any doctrine at all. So we should not engage in scholastics. We have classified all the functions of the state and human rights. And as for the doctrines that the Constitutional Court is currently forming on the constitutional identity of Ukraine should be supported by the Research Advisory Council. And the Council should be a platform to discuss most challenging issues of today. Thank you very much for this opportunity to greet you all. I wish you all to stay safe and stay sane. I congratulate you all on the holiday. Thank you, Yuri.
Well, thank you, Yuri. We'll mark Yuri's birthday on the same day when we're going to celebrate the anniversary of the Constitution. Well, political dialogue is always required in the context of the application of the Constitution. Otherwise, the Constitutional Court may lose its legitimacy. Laws are being judged, and it's not that easy to find the right balance between different competing interpretations. And it is quite natural to speak about pluralism of interpretation until the Constitutional Court says its final say. I give the floor now to Alexandru Tănase, a very experienced person, both in theory and practice. He's an academic. He also presided in the Constitutional Court of the Republic of Moldova. How can the Constitutional Court establish proper dialogue with the society and with the parties to constitutional
Thank you very much, dear Alexander, dear President.
Дуже дякую, шановний пане Топицький, шановний Олександр. Перш за все, я хочу
anniversary of the Constitutional Ukraine. Also, I want to congratulate the Venice Commission for this great idea to support this conference. Yes, to answer to your question, the answer to your question is very close to the topic of this panel. The subject of interpretation in constitutional proceeding. This issue is equally important and relevant, and I'll try to explain you briefly why. You know that among constitutionalists, it's widespread the idea that the constitutional texts are written with invisible ink. The wideness and the deepness of interpretation in constitutional proceedings depends mainly on the ability of the constitutional judges to read those invisible texts and the spirit of the democratic values. Our colleague from Lithuania, Mr. Žalimas, knows we had a huge dispute before regarding the judicial activism. I don't like this word, the judicial activism, because nobody can explain exactly what does it mean. And this is why I prefer to call it as a moral courage of the Constitutional Court to perform their duty. All of us, we know that the constitutional texts are full of values. Therefore, in the absence of this moral courage to see or to understand these values, the Constitution risks to be transformed, as Giovanni Sartori noted, maybe you know, into a facade of the authoritarian source of power. Even in such documents may express respect for human rights or establish an independent judiciary, they may be ignored or maybe never put into practice. I want to briefly refer some judgments adopted by 3 European courts regarding the limits of use of administrative resources in the political process. I think it's a burning issue, not just for Ukraine or my country, Moldova, or for Kyrgyz Republic or for other countries. The last decision or the last judgment, which was adopted on June 9th by the Federal Constitutional Court of Germany. Of course, you know that all of us, we admire the innovative approaches of the German Constitutional Court, but in this case, it's not just the issue regarding the innovative approach. Maybe it's that courts try to respond to a burning issue. It's about the impact of use of administrative resources on the integrity of the policy-making process. So, German Federal Constitutional Court has ruled that the Federal Minister of Interior, Construction and Community violates the right of the political party Alternative für Deutschland by publishing an interview on the website of the ministry. It's very usual for our countries when some different officials use the website of the ministry or the other agencies, not just for the real purpose of this institution, but for other issues, including the issue or the political competition. In this interview, the minister criticized this party and made some negative comments regarding this party. And the court held that the statements made by their minister in this interview are not objectable under the constitutional law, given that they form part of participation in the political debate. However, by publishing the interview on the minister's website, the Federal Minister of the Interior used the resources that are available to him only because of his governmental office to participate in political debate. This is a breach of the state's duty of neutrality, and those violate the applicant's rights to equal participation in the political competition. I will try briefly point just at 3 key considerations of the court. In fact, it's very interesting decision. I recommend to all of my friends to read it, because in the different jurisdictions we can find more or less appropriate approaches, but now it's very clear established what is the limits, admitted limits of using them and the administrative resources. So one of the first issue which I want to point regarding the consideration of the court. In the free democracy, under the constitution, all state authority is derived from the people who exercise in elections and votes, and through specific legislative, executive, and judicial bodies. This requires that voters come to a decision in a free and open opinion forming process. Political parties are of vital importance to this process. There, insofar as possible, equal participation of parties in the political competition is indispensable in order to ensure an open formation of the political will as is required under the constitutional law. Not just according to the German constitution that guarantees that the political parties may be freely established and have the opportunity to participate in the formation of political will, but also that such participation is in line with the equal rights and equal opportunities. You'll agree with me that this statement can be very useful for our constitutional courts, because I am absolutely convinced that we will our courts will be put in the position to deal with such issues. The second point, the right, the court stated that the right is violated where state organs influence elections campaign to the benefit or detriment of a political party or of candidates standing for elections. State organs as such must serve everyone and be neutral. Taking a side during an election campaign violates the neutrality of the state vis-a-vis political parties and the integrity of the formation of the political will of the people in elections and votes. I like very much this expression, integrity of the formation of political will, because they express exactly what is the essence of this value. The court held that the principle of equal opportunities of political parties requires that the principle of neutrality of the state be observed not just during election campaign, given that the formation of political will is an ongoing process that is not restricted to electoral campaign. You will agree also that is very, very important issue, because the court decided not just regarding the essence of this right, but at the same time described that it's not limited to the political, to the electoral campaign, because in fact, when we are talking regarding the electoral fraud, this fraud most likely happened not in the campaign, but before and during the period of time between the campaigns. And the last point, key issue held by the court is the power to inform the public and to maintain public relations. It's an integral part of the task of government. This power is not just permissible under constitutional law, but is necessary in order to preserve a basic consensus within a democratic community and to enable citizens to independently participate in the formation of political will and tackle the current problems. It must, however, be considered that the federal government authority and the state resources at its disposal put into a position where it can exercise lasting influence over the formation of the political will of the people. And this carries the risk that the political competition of the party is considerably destroyed and the process of the formation of political will is reversed, so that it originates from the state rather from the people. Thus, the federal government public relations activity are no longer permissible where it used the influence in favor or against the individual competing political parties and persons. The second example is from the case law of the Constitutional Court of Moldova, of my country. The Constitutional Court of Moldova has been called several times to rule on the impact of use of administrative resources on the integrities of people's political will-forming process. One of most relevant examples is ruling of the Constitutional Court from the 12th of December 2017 regarding the constitutionality review of some provisions of the Electoral Code, which prohibited the president of the country to be a member of political party. In this case, in a similar manner to the German Constitutional Court, the Constitutional Court of Moldova concluded that restricting the political activity of some public authorities pursued a legitimate aim, taking into account the need to guarantee their political neutrality and to ensure they fulfill their obligation in an adequate and impartial manner. In particular, in this case, the court found that the provisions of the Constitutional Code, according to which the term of office of the president of the country, the republic, is incompatible with the membership of the political party, were constitutional, and that the president of the Republic of Moldova may not be member of a political party and is not allowed to promote in any way the interest of any political parties. And the last but not least example is from the case law of the Constitutional Court of Lithuania. All of us, we know that it is a very strong court, and the case law sometimes was used by our court and the lay as a ground for our decisions. So the Constitutional Court of Lithuania has adopted several rulings on the issue of the legality of elections, where it has held that in a constitutional democracy, representative political institutions may not be formed in a such way that would raise doubts as to their legitimacy and legality, inter alia, as to whether the principles of democratic states under the rule of law were not violated in the course of the election or of person to representative political institution. The court held that democratic elections are an important form of citizens' participation in the governance of the state, as well as necessary element of the formation of state political representative institutions. Elections may not be regarded as democratic, nor their result as a legitimate and legal, if the elections are held by trampling of the principles of democratic elections established in the Constitution and violating democratic electoral process. In its ruling from 24 May from 2014, the Constitutional Court of Lithuania has mentioned that if during the elections certain gross violation of the principle of democratic, free and fair elections were committed, and that those violating might have destroyed the genuine will of the voters with the aim of electing certain candidates, these candidates may not be awarded to a mandate of a member of the Sejm, the Lithuanian Parliament, since otherwise the confidence of the nation in its representation and the state itself could be undermined. So, as a conclusion, I want to have a great pleasure to welcome here the Professor Rainer, because due to the coronavirus, I had the possibility to meet him in the last months. And I remember that he used to mention often that the constitutionalism is the perfection of the rule of law. In this context of this concrete discussion, these three judgments come to reflect this statement, and it's important not to interpret them stricto sensu. They must be understood much more widely. The Constitutional Court of these three states have not only established the several fundamental principles regarding the impact of use of administrative sources on the integrity and free and open forming process, and the permissible limits of this regard, that these three courts, in fact, strengthening the public confidence in the, from one side, in the rule of law, and from other side, in the constitutional courts, and their role of guardian of constitution, as it was defined by Hans Kelsen. Thank you very much for your attention. And once again, I want to congratulate the host and the Venice Commission, the OSCE, for this wonderful organized event.
Дякую, пане Олександре.
Thank you, Alexandro, for this in-depth response to the issues raised by our panel. And now we will give the floor to Mr. Karibek Deshev, Chairman of the Constitutional Chamber of the Supreme Court of the Kyrgyz Republic. The floor is yours. Thank you, Alexander. Dear colleagues, first of all, allow me to thank Mr. Alexander Tupitsky on behalf of the Constitutional Chamber of the Supreme Court of the Kyrgyz Republic for the invitation to participate in this conference. I would also like to use this opportunity to share some considerations regarding the topic of this panel and share some of our own case law. Indeed, the body of constitutional control in any country, irrespective of the legal system that they belong to, deal with the fundamental law of the constitution of the country. A constitution to us is a yardstick against which we actually measure the provisions of the law. That's why the acts of the Constitutional Court act as as I said, the yardstick or benchmarks for the legislation. So the availability of the act of the Constitutional Court on a certain matter of law helps to apply the law and actually adds a new perspective to it. According to the Kyrgyz constitution, every person is entitled to challenge the constitutionality of a law or a regulation if they believe that this norm, law or regulation violates their rights, according to Part 7, Article 97 of the Constitution. So our case law is focused mostly on the complaints about the limitation of constitutional laws and freedoms of the citizens, and in particular falling under Article 20 of the Constitution. In order to avoid the frivolous interpretation of the Constitution and to interpret it correctly, the Constitutional Chamber, in its first ruling of 29th of October 2013, set the frameworks within which any limitation should actually pursue the constitutionally valid purpose and should be dictated by the need to protect the values protected by the Constitution. Moreover, while interpreting the provisions of Part 2, Article 20 of the Constitution, the Constitutional Chamber established that limitations that are not envisioned by the Constitution and law cannot be introduced by secondary legislation. And this legal provision or position has been developed by the Constitutional Chamber in its decision of 2014, whereby the limitation of rights and freedoms of the citizens is admissible only under certain strictly defined conditions. First of all, it should be presented in a strictly defined legal norm that is that is in the form of the law, and it should pursue a certain aim that is mentioned in Article 20 of the Constitution of the Kyrgyz Republic. The limitation is only admissible to the extent necessary for the protection of constitutional values or certain values indicated in the Constitution. Later, the decisions of the Constitutional Chamber were based on those legal positions which guide us in ensuring correct understanding and interpretation of the constitutional provisions. The constitutional control bodies as the major subjects of implementing constitution play the key role and that will prevent the emerging of competing interpretations of the court. The Constitutional Chamber through promoting constitutional values in the national legal system is of paramount importance in democratizing the legal regime of the country. Thank you very much for your attention. That is the end of my intervention. Thank you very much, Mr. Daishev, for this report, for the overview of your Chamber's Court law. And now I will give the floor to Mr. Pavlo Pushkar, who is head of division of the Department for the Execution of Judgments of the European Court of Human Rights, Director General of Human Rights and Rule of Law Council of Europe. And we understand that the court, Constitutional Court, has got a stable doctrine of friendly attitude to the international law, including case law of the European Court. So, Pablo, the floor is yours. Thank you very much for the invitation, and I hope you can hear me.
Шановний пане голово, шановна пані голова Верховного Суду,
esteemed head of the chair of the Constitutional, President of the Constitutional Court, esteemed President of the Venice Commission, Madam President of the Supreme Court, thank you for inviting me to participate in this extremely interesting and intensive event. I would also like to thank the organizers, the Constitutional Court of Ukraine and the Venice Commission, OSCE, PCU, that I suppose faced a lot of organizational challenges in co-hosting this event. Before starting the presentation proper, and it will deal with the subjective and objective elements related to constitutional proceedings, I would like to comment in brief on the issues raised by Mr. Kostin, in particular on the implementation of the Convention and case law of the European Court. There are situations indeed where the adopted law with previous negative opinion of the monitoring bodies will be assessed in judgments by the European Court and then will have to be executed by the country. The position seems to be very clear-cut, but actually it might be distant from the facts and events reflected in the judgment. Hence, the difficulty of forming the execution measures and general measures to execute the court's decisions. As for the dialogue that Mr. Kostin mentioned, together with the chair of the Parliament and chair of the Supreme Court, this issue relates to the adoption of laws, particularly in the context of the judicial reform, to which the decisions of the Committee of the Ministers point, particularly regarding the reform of 2019. And I am glad that it is our joint position, and the Council of Europe is there to support Ukraine in terms of expertise and support of the dialogue. As for my presentation proper, I would like to draw attention to the execution of the European Court's decisions regarding Article 9 of the Constitution and of the Convention. And as Mr. Zikmopoulos said, there is just the limitation of the vision of the norms of the international law as the norms of the positive norms. You will know that sources of international law, according to Article 38, are not only norms of the International Convention and international treaties actually ratified by countries or acceded to by the countries, but also international tradition and the principles of the law recognized by civilized nations, and research as additional ways to recognize the norms of international law. So in the declaration of the state sovereignty of Ukraine mentioned earlier during the day, actually refers to the priority of the international law instruments and prevalence with regard to the national law norms. So I would like to draw your attention to the general principles of the international law, that is the commitment to peacefully resolve disputes, particularly what concerns the obligation to ensure access to justice, including international justice. According to Article 55 of the Constitution of Ukraine, that you all know very well, but I would like to mention it here again, because everyone, upon exhausting the national remedies, is entitled to go to or to turn to international organizations or international judicial institutions that are members of the organizations that Ukraine is also a member of. And I would like to draw your attention to the case law of the Constitutional Court with regard to Article 55 of the Constitution of Ukraine, according to which, in particular, justice is recognized as such only if it meets the requirements of fairness and reinstates effectively the violated rights. That's the ruling of the Constitutional Court of 2003. The ruling of 2009, I would not be actually quoting the entire text of those decisions, but the Constitutional Court actually says that the principles of the rule of law requires, in the context of protection of constitutional rights and freedoms, to reinstate the electoral rights of an individual, and the insurance of promotion of rights and freedoms requires also judicial protection. And the Constitutional Court, in its ruling of the 9th of September 2010, is that the judicial protection is one of the most effective remedies. So as for the execution of courts, the Constitutional Court in its ruling of 2012 says that the execution of the court decision is the indispensable element of the right to judicial protection, and thus the commitment to exercise or to execute the court decision is just the obligation of the state. And in its decision of the of May of 2012, the CCU says that failure to perform or to execute decision threatens the violation of the international law norms. So, Article 55 of the Constitution guarantees the right to judicial protection and reinstatement of the violated rights. So, the right to restitutium in integro, according to the European Convention. And Article 55 also defines the judicial enforcement as an indispensable part of the right to the access to justice, according to Article 56 of the Convention. And the execution of court decisions is mandatory, and it should lead to the reinstatement of violated rights. And within the context of a friendly attitude to international law and requirements of Article 46 of the Convention on the execution of the ECTHR decisions or judgments, we also speak about Articles 26 and 27 of the Vienna Convention on the law of international treaties. The question is whether the Constitution of Ukraine directly guarantees through the rule of law the right to the execution of ECTHR's judgments as such. I believe that the answer is positive, and the exercise of this right is also part of the right to access to the international courts. And this right would be illusory without the obligation to execute such decisions, which is the essence of the international law instrument to which Ukraine acceded. And if the convention violation is recognized recognized, and the right should be reinstated through individual measures and other executive measures. What should we do when when the national legal system has a systemic problem mentioned by the ECTHR judgment? And here we can refer to the rule of law checklist of the Venice Commission on the measures of the rule of law. Some items of this provision say that the law, according to this checklist and standards of the Venice Commission, also coincide with the international law, the principle of pacta sunt servanda, as part of the Vienna Convention, Articles 26 and 27. And it is a way through which international law expresses the principle of legality. The principle of the rule of law does not impose on the state the choice between dualism and monolism, but the relation between international and national law should be observed. Court decisions or court judgments are important for the application of law and constitution. The right to fair trial and rule of law would be devoid of any sense should these judgments fail to be implemented. The right to fair trial is a right that requires the execution of all courts, including constitutional ones. And in this context, we can be speaking about the decisions or judgments of ECTHR as a body with special status in the system of European constitutional democracy. The principle of the rule of law, which is an indispensable part of the Constitution enshrined in Article 8 of the Constitution in conjunction with Article 9 and 55, provisions of the Declaration of the State Sovereignty of Ukraine, means that the execution of judgments of ECTHR is the constitutional right of Ukrainian citizens, and individuals can rely on it when they get the positive judgment of ECTHR. Individuals have the right for the protection of those constitutional rights, or entitled to the protection of those constitutional rights. And I would like to draw your attention to the latest publication of our department. It's a document which is a compendium of best practices of constitutional jurisdictions related to the execution of ECTHR judgment. It is publicly available on our website, our department's website. We will be happy to share it with you, and we hope that later on we will have an opportunity to have it translated into Ukrainian. Thank you very much for your attention. Should you have any questions, I'll be glad to answer them. Thank you. Thank you, Pavla, for our most interesting presentation and comments. Unfortunately, we are behind our time, for which I apologize to our participants. If I may, I would like to thank all of the speakers and discussion participants for such great food for thought. And I would like to make an announcement. Our next panel, panel 4, will start in 15 minutes. That is at 3:10 Kiev time. Thank you very much. Now, a 15-minute break.
Почнемо. Так. Доброго дня всім. Я радий, що маю честь модерувати на завершальній нашій четвертій панелі, яка називається «Рішення Конституційного Суду України як тлумачний інтерпретаційний акт».
Panel. Decision of the Constitutional Court as an interpretative act. I introduce our speakers, Lars Brocker, President of the Constitutional Court and the Higher Administrative Court of Rhineland-Pfalz, Germany, Igor Rogov, member of the European Commission for Democracy through Law, Chairman of the Constitutional Council of Kazakhstan in 2004-2017, Deputy Executive Director of the Fund of the First President of Kazakhstan, Rainer Arnold, Professor of the University of Regensburg, Germany, our old friend. Another big friend of our court, Daniel Žalimas, President of the Constitutional Court of Lithuania. Ivan Dombrovsky, former judge of the Constitutional Court of Ukraine, chairman of the Association of Judges of CCU, and Hennady Ryzhkov, legal advisor of the German Foundation for International Legal Cooperation. At the three previous panels, we addressed the interpretative role of the Constitutional Court, the role played by the court in each proceedings and in preparing each ruling, as well as the role in motivation of each ruling. And we also touched on whether the constitutional courts have to interpret laws. And I liked very much what Ms. Denishevska, President of the Supreme Court, said. I am certain that we shall continue our proceedings in a very intellectually intensive manner, as Pavlo Pushkar says. It's my great pleasure to give the floor to Lars Brocker. President of the Constitutional Court and the Higher Administrative Court of Rhineland-Pfalz, Germany.
Є картинка. Хвилинку, технічна проблема. Зараз працюють над відновленням зв'язку і перекладом. Хвилинку.
Jetzt? Können Sie mich jetzt hören? Hallo?
Yes, I hear you.
Sie mich hören können? Ja? So should I start again from the beginning?
So now you can hear me, yes? Okay.
Yes, we can hear you now.
Yes, okay, fine. Decisions of the Constitutional Court, I'll start at that point, are of course not a political act, but an interpretative act. The court works with the tools of jurisdiction. As the first president of the Federal Constitutional Court in Germany aptly stated in 1953, as judges, we are only servants or workers in the vineyard of the law. But the decisions of the Constitutional Court, of course, have a political effect, as we all know. Therefore, it is very important to work in strictly legal terms. In my following comments, I would like to point out the wide margin of the Constitution as a system of meanings and fundamental values. Interpretation of the Constitution also means its cautious development. And the Constitutional Court is not that much bound, especially not by interpretation of the Constitution by means of only what the mothers and fathers of the Constitution meant. Well, some say this alone, the historical point of view, should be the guideline for the interpretation of the Constitution. For any problem which couldn't be solved that way, the Constitution holds no answer, they say. In the US, this doctrine is well known as originalism. I don't agree with this doctrine. Instead of that, I would like to point out the figure of alteration of the Constitution by interpretation of the Constitution. It is that concept which determines the practice of constitutional jurisdiction in Germany, and by the way, all in all, also in the US. It is only a small group of right-wing conservatives which stands for originalism. Hence, first of all, let's face an apparent paradox. The Constitution is a political document, a foundation of the state, takes effect from the past into the present. It determines this present at specific proceedings, values, and bounds. That means a structural dilemma. On the one hand, constitutional law, first of all, should ensure stability. On the other hand, the Constitution should also not turn into stone, because it has to give suitable answers to present questions. This requires special needs to the practice in every particular case, which means the interpretation by the Constitutional Court, because its decisions are binding. And because of judicial practice always being a creative act, interpretation of the Constitution implies an alteration of the Constitution, or in other words, there sometimes is a need for concretions and readjustment. Just like the concept of alteration of the Constitution overcomes the balancing act between time and Constitution. The conclusions are drawn out of the conditions of a constitutional rule, which probably have changed over the years. And therefore, the rule probably also has a different meaning, or in other words, to say it strikingly, constitutional jurisdiction means changing the Constitution inconspicuously. In one of its decisions, the Federal Constitutional Court pointed out that the judge in European history never acted just like the mouth, which only speaks out the order of the law. But on the contrary, that Roman law, the English common law, and the German law preponderant were creations of jurisdiction by the judges. Jurisdiction is a creative act. This also counts for constitutional jurisdiction. Hence, the answer to constitutional questions is not given by the historic legislator. The answer to constitutional questions is given by the Constitution itself, as it is an organic, alterable whole, as the former judge of the US Supreme Court, Oliver Wendell Holmes, pointed out. It is given by interpretation of first, the wording, second, the systemization, and Third, sense and intent of a legal norm. The historical background of a legal norm should, fourth, only count to prove the result, which was found by using the three mentioned methods of construction and interpretation. In any case, this exactly is the jurisdictional practice of the Federal Constitutional Court in line with constant jurisprudence. And as being an organic whole, the Constitution is alterable. To think in legal terms, alteration of the Constitution means to change the original meaning of a constitutional legal norm or of certain parts of the Constitution without changing the text. Nevertheless, if this alteration is intended by the court or not. Thus, alteration of the Constitution first and foremost occurs when Constitution is applied, and the final interpreter of the Constitution, of course, is the Constitutional Court. Hence, alteration of the Constitution is a phenomenon which might show up if one has to concretize a constitutional norm, which to a certain level is undetermined. Therefore, alteration of the Constitution happens if a concretization of a constitutional norm is replaced or complemented by a new concretization. The Federal Constitutional Court is different from the other state entities, not bound by its own judgments. In case of better insight and awareness of a legal norm, the court could change even its constant jurisdiction and established law practice. The Federal Constitutional Court, of course, deals very cautious and circumspect with that. But there are quite a lot of examples recently in 2017, rather spectacular in the context of prohibition of an anti-constitutional party. Nevertheless, some people reluctant when facing the phenomenon of alteration of the Constitution. Why? Because the need of stability is such strong, because one is of the opinion that stability and alteration are mutually exclusive, or because one is of the opinion that it is only a political matter which is not a court's business. Well, that at least is not the way a constitutional state under the rule of law works. The state under the rule of law does need a guardian of the Constitution, the Constitutional Court. And constitutional jurisdiction is all in all inconceivable without alteration of the Constitution. Hence, it is also obviously that the Constitutional Court is not only the guardian of the Constitution, but also the guardian of the alteration of the Constitution. I would like to close with a personal remark and congratulate you once again on the Constitutional Day and on this conference and the well-chosen topics. This underlines the Constitutional Court's importance to the state's structure and the basic rights of the Ukraine people. Дякую.
Дякуємо вам. Дуже цікаво для нас.
Thank you. Germany is very interesting and important for us because of its traditions of constitutional justice. Thank you again, Mr. Brocker. And let me give the floor now to Igor Rogov, a member of the Venice Commission. The floor is yours.
Good afternoon, dear participants, dear colleagues, judges and justices. It is my great pleasure to greet you. I respect the Ukrainian language, but with your kind permission, I will switch to Russian. It is my great pleasure indeed, dear colleagues, to see you here, particularly Mr. Holovate, who we often meet in Venice. he's a great friend of my country, and I am extremely satisfied to see him, albeit online. I'm glad to see here Mr. Larry Broker, with whom I've often talked in Germany and met him back in my country. We have very close relations with our German colleagues, not only with the Constitutional Court of that country, but also with other legal professionals. The same pertains to the legal professionals in Ukraine. We cooperate with the representatives of the prosecutor's office and with the judges. And we have a lot in common in introducing judicial and constitutional reforms. Now focusing on the topic of today's discussion and the operation of the Venice Commission, I can tell you that Kazakhstan had a status of the observer of the in the Venice Commission for 14 years, since 1998. And now we've become the fully fledged members of the Venice Commission once the first president of Kazakhstan, Mr. Nazarbayev, actually applied to full membership of the Venice Commission. This act followed the decision of the Committee of Ministers to satisfy the request or to respond positively to the request of Kazakhstan. Our participation as a full member of the Venice Commission has got or entails a lot of benefits. It allows us to access cutting-edge legal technologies. It's an additional channel of raising awareness and education about practices of other countries. It also enables us to seek opinion of the Venice Commission on our legal acts, thus preventing potential mistakes in legislative activities in lawmaking. And we've used this opportunity to the full. In 2007, the Commission prepared opinion on the Ombudsman's role in Kazakhstan. The Commission, of course, does not interpret our constitution directly, but it's thanks to those opinions that we can conclude in the Constitutional Council and in Parliament on the constitutionality and conformity of certain proposed provisions with the international law and thus with the national constitution. We had an opinion on the ombudsman role and powers, and at that time the ombudsman was appointed by the president. 10 years later, that is in 2017, the recommendations of the Venice Commission were ultimately implemented, and today our Ombudsman for Human Rights is elected by the upper chamber of our parliament, the Senate, on the recommendation of the Chief of State. And in 2011, the OSCE offered an opinion on the judicial system and the status of judges in the Republic of Kazakhstan. And in 2017, an opinion was pronounced on the Code of Judicial Ethics. And right after that, we launched an in-depth and comprehensive judicial reform, and Mr. Broker can confirm that the delegation of Kazakh lawyers visited Germany. We met in person with Mr. Broker then, and best practices of our German and other European colleagues, as well as that of the Ukrainian colleagues, is very instrumental in our improving our legislative activities. And in 2017, we got an opinion on the draft law on administrative procedure and amending the Constitution of the Republic of Kazakhstan. I will comment on constitutional amendments a bit later. Now I will tell you the following. In the opinion on the draft law on administrative procedure, the Venice Commission actually helped us to interpret the law in favor of adopting special administrative court of procedure, or code of administrative procedure. And quite recently, it was also considered or examined by the Venice Commission. The overall conclusion was very favorable, with certain very constructive remarks and recommendations. And I would like to thank Mr. Bukikio and other members of the Venice Commission for their opinion. Quite recently, our parliament adopted this code, and now it is pending signature by the president. Now, speaking about the interpretation, I would refer to the opinion in response to the request of the Constitutional Committee on the compatibility of our legislation with that of the Customs Union with the Russian Federation and the Republic of Belarus. There were a lot of discussion and debate as to whether the signing of this treaty runs counter to the national sovereignty of our republic. And the Constitutional Court relied on the opinion of the Venice Commission in its ruling. Those recommendations were taken on board by international structures, and when the Eurasian Economic unit was formed, those recommendations were heeded. The Venice Commission recommendations are also taken into account when we draft legislation and when very important decisions of the state or public administration and state order are being taken. I would also like to underscore the role of the Venice Commission's opinion on constitutional amendments. The reform that the Constitutional Commission launched allowed us to democratize the fundamental law in transferring some of the presidential powers to the government, to parliament, and to other agencies of power, public agencies. And here I again would like to thank Mr. Bokikio, who said that the Venice Commission at that notes the consistency of democratic transformations in the Republic of Kazakhstan several years ago and now as a result of the ongoing constitutional reform. A couple of words now about the economically significant results of the reform. Because based on the initiative of Mr. Nazarbayev, we established the International Financial Center in Astana, and its legal institutions work in accordance with the common law, which is the law of this center. It is based on the common law, and here when we have to somehow combine two different legal systems, we actually had this challenge of preserving the national sovereignty over that territory and using best foreign practices, best international practices. And again, we are here very thankful to the Venice Commission for the consultations that they provided. Dear colleagues, I understand that our time limits are very tough, and I would not actually abuse your patience. I know that you are going to publish the communications of this conference, so I hope that you will be able to read my presentation in a fuller form. Thank you very much for your attention. Thank you for inviting me. All the best. Thank you for keeping within the time limits.
Слово наступному доповідачу Райнеру Арнольду, професору Регенбурзького університету. Прошу.
Our next speaker is Rainer Arnold, professor of Regensburg University.
Попросите его unmute the mic.
Your microphone is off.
The microphone? Okay.
You have to switch it on, yeah.
Is fine now? Okay. Thank you, Mr. Chairman, for giving me the floor. First of all, I want to thank very cordially and to congratulate to the President of the Ukrainian Constitutional Court, Mr. Tupitsky, and to congratulate for the 24th Constitutional Day of Ukraine. And I want also to congratulate the Venice Commission for the 30th anniversary. And it's really a very important event here that you festivate these two events together. For analyzing constitutional interpretation by constitutional courts, it seems to be necessary to have a brief look at the structure of the Constitution itself, because the interpretation of the Constitution has to be embedded in its basic structure. Constitution is the fundamental legal order of a state and establishes an institutional system and determines values, the fundamental rights, based on the idea that constitutionalism of today is, as I call it, anthropocentric. That means that its ultimate finality is a protection and promotion of the individual, the human being. Human dignity is therefore the core value, which is necessarily connected with its twin principle, the principle of freedom. This includes individual and political freedom, also democracy. Human dignity, freedom, democracy, and rule of law form a functional unit. We can furthermore say that rule of law is rule of both national and international law. This includes the openness of the national legal order towards the international community. The formerly closed state is an open state today. Open statehood has become an essential element of the Constitution. I speak of the basic structure of the liberal democratic constitution, but this is the only real model of contemporary constitutionalism. If one of the basic elements of this liberal democratic constitutional order does not exist in a state, it is not a constitution in my view, it is maybe an autocratic statute or something else. Constitutional interpretation has to explore the will of the Constitution in an objective way and in the moment of the interpretation. President Broker has already pointed out what I'm in the same line as you are, Mr. Broker, but I want to repeat it. Neither the historic perspective of the authors of the Constitution, might it give some subsidiary indications, nor the text as objectively understood in the moment of the adoption of the text. As a textualist, a constructionist, or you said the originalist in the United States are inclined to assume is decisive for the interpretation of the constitutional text. Decisive is the objective finality of the Constitution in the moment of its interpretation, which results from the interaction between the wording of the text and finally of the society. In Europe and in large parts of the world, the rather legalist perspective has disappeared, not least due to the influence of the jurisprudence of international courts. So, for example, in Austria, for the interpretation of fundamental rights by the Constitutional Court, importantly influenced by the dynamic, evolutionary, and effet utile-oriented approach of the European Court of Human Rights. However, there seem to exist some tendencies, in particular in transformation countries, to apply a principally text-oriented approach in interpreting the constitutional document. A constitution contains preponderantly in the part of values, in the part on fundamental rights, rather undetermined open provisions, which are to be concretized by the interpreter, finally by the constitutional judges. This enables and obliges them to take account of the significant societal changes, in particular in the value convictions. An important role in this context belongs to the legislator, which is, as the German Federal Constitutional Court says, the first interpreter of the Constitution, of course, under the regime and review of the Constitutional Court. The legislator transforms politics expressed by majority will in parliament, or in other systems in referendum, into law, into legislation. As politics is a continuous daily process in a free society, politics reflects the changes in society, and by this generates impulses in the life of the Constitution. It gets evident that politics legitimately impacts, also not exclusively, the interpretation of the Constitution. Of course, constitutional review by the Constitutional Court examines this impact of the legislator and, if necessary, corrects it. Constitutional interpretation, this must be confirmed again, and this has been also expressed by President Broca, is not political jurisprudence. The interpretation of the Constitution and also its application by courts is by nature different from politics, though it has a large-scale influence on it. Constitutional law and politics expressed by legislation cover two complementary spheres which might impact reciprocally, but which are necessarily separated one from the other and of a different nature. Constitutional interpretation starts with the text and the textual systematics, but does not stop at the letters. It has to look behind the letters, has to explore, as already said, the will of the Constitution in the moment of the interpretation, which embodies the purpose of the provision. Each constitutional provision has, in my view, two sorts of purpose, two sorts of telos. What is important within the teleological interpretation, the specific purpose, the specific telos to realize or to contribute to realize the immediate aim of the provision. And this is in an efficient way. And and this is the specific telos, and the general telos, the general finality, is to fit in the constitutional norm to be interpreted with the above described fundamental framework of liberal democracy, which is, as I underlined, necessarily the basic structure of a contemporary real constitution. This means that the relevant constitutional provision has to be interpreted in the perspective that it is necessarily an element of this basic structure and has to be therefore adjusted to it. This interpretative perception allows also to derive from this basic structure framework elements which are not expressly written in the text of the Constitution, but have to be considered as a necessary attribute or necessary attributes of this structure. In this basic structure of a liberal democratic constitution, with all elements which are necessary for this structural framework, all these elements form a functional unit and are functionally interdependent. If one essential element of this framework is not written, it is, however, normatively existent and can therefore be discovered, not invented, discovered by the constitutional judge. This also implies that it is all the more possible and even necessary under this perspective to interpret a written constitutional provision in the light of this basic structure of the liberal democracy. This is a system-adequate interpretation. If we accept, and this is nearly a common conviction today, that the Constitution has to be interpreted in the sense how it must be understood in the moment of the interpretation. It is the requirement fulfilled, the requirement of an evolutionary interpretation, which takes adequately into account that the Constitution is a living instrument. This also accepts that the sense and finality of constitutional law can change, can evolve. Changes of significant impact can take place on the side of the norm, new orientations in value perceptions, functional enlargements of the terms used in the provision, changes in politics and economics which modify the inner reason of the norm, etc. But changes can also take place on the side of the norm addressees. These processes of change can be relevant for the reinterpretation of the constitutional norm and concept. However, conceptual stability is of importance, and this is what, for example, the Lithuanian Constitutional Court confirms very clearly, is important, in particular where the basic legal order of the state is concerned. It is due to prudence and moderation of the judges how far they can legitimately develop the constitutional law by transforming societal changes into constitutional interpretation without threatening the basic principle of separation of powers. These processes are in particular relevant for the value part of the Constitution, the fundamental rights. In the institutional area of the Constitution, the possibility of evolutionary interpretation is much more limited. In this field, changes are regularly left to formal constitutional reform, of course, a politically difficult and lengthy process. However, judicially developed principles with institutional relevance do clearly exist. To take German examples, federal loyalty, financial solidarity between the member states of the federation, interinstitutional loyalty, the application of the principle of proportionality also in the institutional field, all these are results of judicial interpretation developing constitutional law, not only in the field of values, but also in the field of institutions. A further function of constitutional interpretation shall be added very shortly, the internationalization with regard of the member states of the European, I would say, the supranationalization of constitutional law. National constitutional orders shall not differ from the basic concepts, in particular in the field of human rights, from the international community. Values concerning the human being are universal. Individual rights, democracy, and rule of law, as they are functionally interconnected, are object of all levels of law, also and in particular of international law. The jurisprudence of the European Court of Human Rights has leading influence on the interpretation of national constitutional law. A significant divergence is not acceptable. Might it be possible to guard to some extent a national perspective within the margin of appreciation admitted by the Strasbourg Court? It is a merit of the Venice Commission to have observed and to observe continuously the constitutional developments in all the member states, whether they correspond to the European requisites as pointed out by the court and the Commission. These merits are really of a highest degree. So I tried to very shortly outline the function of the Constitutional Court when interpreting the Constitution. I think that indeed the finality of the Constitution is the central point of interpretation, and this finality has to be conceived and understood in an objective way, and also related to the moment of the interpretation. And this includes the acceptance of an evolution of the Constitution, which is a living instrument. Living instrument, this term has been used by the European Court of Human Rights, but it can be transferred and has been transferred also to national jurisprudence. And for this, the dynamic, the evolutionary character of the Constitution must be respected and must be taken into consideration by the interpretation, and of course with a great extent of prudence, and always to be aware that this is interpretation, this is developing of law, is a legitimate aim and task of the constitutional interpreters, but it is not creating and making a new law. This would be against separation of powers. But I think that the constitutional courts, as far as I can see it, and only to summarize so roughly, they are in a good way to understand the constitution, and judicial constitutional activism in reality does not exist. It is the developing of the constitution, and it is not constitution making. So thank you so much for your attention.
Дякуємо вам. Я хочу оголосити, що ми переходимо до дискусії в рамках нашої четвертої панелі. І перед тим, як надати слово Денісу Жалімасу, я хотів би озвучити питання, які пропонуються для дискусії, в тому числі, можливо, і пан Деніс на них зверне увагу. От пані професор Крусян Анжеліка Романівна, вона запитує, яка роль, власне, тлумачення у конституційному судочинстві саме для розвитку парадигми конституціоналізму, і, зокрема, в нашій країні, я так розумію. Пані професорка Москвич Лідія Миколаївна також запитує, що якщо може мати місце відхід від власної позиції, сформульованої Конституційним судом, то, я так зрозумів, а який механізм має бути такого відходу? Окремо наш колега, суддя Конституційного суду у відставці Кампо Володимир Михайлович, він запитує, а чи потрібно окремо закон про виконання висновків і рішень Конституційного суду? Це ті запитання, які пропонуються для обговорення. І я з задоволенням надаю слово Денісу Жалімасу, голові Конституційного суду Литовської Республіки. Раді бачити.
Дуже дякую. Дуже дякую, шановні колеги.
Thank you very much, dear colleagues, dear friends. First of all, on behalf of the Constitutional Court of Lithuania, I would like to congratulate you on the 24th anniversary of the Constitution of Ukraine, and I switch into
I'll try to answer to
English.
some questions just posed by you, but I would like to start initially with how the act of the Constitutional Court should be understood, and only some points. Of course, it is interpretative act, but it should be seen as interpretative act with, let's say, two aspects or two directions. First of all, it is interpretative act of the Constitution, and the second, it doesn't matter whether you have this function in the Constitution or not, but it is also interpretative act of the laws under verification by the Constitutional Court as well. Why? Because just in order to establish whether a certain law which is disputed by a certain party, in your case law, you need first of all to find the exact meaning of a disputed provision of the law before the court. And sometimes it could happen. Of course, first of all, it is the function of ordinary courts like Supreme Court, like, I don't know, Supreme Administrative Court, to interpret ordinary laws. But sometimes it can happen when interpretation given by the Constitutional Court can be the opposite or be different from that given by ordinary courts and administrative courts. And why it can happen? I can briefly mention one example from the Lithuanian case law. Last year, the Lithuanian case law ruled that the law on the status of foreigners is compatible with the Constitution. But the decision of the Constitutional Court, such a decision was taken due to the fact that the Constitutional Court actually disagreed with the interpretation given by ordinary courts. The law concerned reunification of family, reunification of the same-sex families, if to be precise. And of course, there is one more, let's say, methodological approach in the constitution, in the practice of the Constitutional Court, that is the presumption of constitutionality of laws. So, according to this presumption, that the Constitutional Court should, first of all, establish and should use all the possibilities to interpret the ordinary legislation so as it could be compatible with the Constitution. Because the ordinary courts who applied to the Constitutional Court with a petition were of opinion that because of traditional notion of family in Lithuania, this law does not provide the possibility to reunify the same-sex families. Then the constitutional, but you know, under the law, there was no mentioning about the spouse, about the sex of spouse of the family in question. So that's why the Constitutional Court found the possibility to interpret the law that it does not prevent to reunify the same-sex couples. And also the Constitutional Court went further, but it is another aspect of the act of the Constitutional Court as interpretative act. I mean the interpretation of the Constitution, and the Constitutional Court also found that the family, constitutional notion of family is gender neutral notion. It's not the same as the notion of marriage, which I believe is perhaps identical to that in the Constitution of Ukraine, that marriage can be only between men and women, but there is nothing said similarly about family, and family can be founded not only on the basis of marriage. So because the Constitutional Court found that according to the Constitution, protection of family life should be also expanded to the same-sex couples, and the law also literally didn't prevent the interpretation of reunification of families as applicable to the same-sex couples. Then the final ruling of the Constitutional Court was to just to take the different interpretation of the law than was previously adopted by ordinary courts, and because of that different interpretation, this law was recognized as compatible with the Constitution. That is only one example. Of course, it is very rare case when the Constitutional Court comes to different interpretation of laws than ordinary courts, but it can also happen. And in this aspect also I should mention that in this case the interpretation of the Constitutional Court overrules the interpretation of ordinary courts, because the decisions of the Constitutional Courts as a whole, be it interpretation of laws, be it interpretation of the Constitution, they are all binding on all subjects, including the Constitutional Court itself, and they also binding on other courts. So from that ruling of the Constitutional Court, the ordinary courts had also to change their practice in interpretation of laws. And of course, the second meaning of the act of the Constitutional Court as interpretative act, that is interpretation of the Constitution. Here, the Constitutional Court undoubtedly should have exclusive competence. Nobody else can interpret the Constitution, neither the Parliament nor any other court. That is exclusive function of the Constitutional Court. And in this regard, we use this term already used by previous speakers, official constitutional doctrine. I must stress that official constitutional doctrine is provided by all the acts of the constitutional courts. That is the official interpretation of the constitution in the acts of the constitutional courts. And the official constitutional doctrine also binding on the constitutional court itself. So it must follow this official constitutional doctrine, and it is applied as an integral and as a whole in all the appropriate constitutional justice cases. But just reacting to some maybe remarks by previous speakers, I must also emphasize that what is the development of the official constitutional doctrine. Of course, it is developed not only by means of literal interpretation, not only following the letter of the constitution, but also the spirit of the constitution. What is the spirit of the constitution in the official constitutional doctrine of the Constitutional Court of the Republic of Lithuania? It is the overall constitutional regulation, including also constitutional principles. And here I should disagree with one previous speaker when she mentioned that some of the constitutional principles, they are only political declarations. Once they are inserted in the constitution, they all have constitutional and legal force and should be taken into account when developing interpretation of the constitution, even if may have certain political content. Let's take as an example, for example, the principle of geopolitical orientation. It is not only political slogan, it is not only political declaration, but it also obliges the Constitutional Court to take into account the European legal context, for example, when interpreting the Constitution. And perhaps, of course, I agree that the interpretation of the Constitution should not be static, should be dynamic. The Constitutional Court on case-by-case basis should also take into account all the legally or constitutionally significant changes in public life, all the challenges, new emerging challenges to the constitutional values protected by the Constitution. But I would also to mention one more point. It was also perfectly revealed by previous speakers, but nevertheless, that is friendly approach to international and European Union law. So again, the Constitution itself obliges the Constitutional Court to harmonize two imperatives of the rule of law, that is universal value, that is supremacy of the Constitution, and also with respect to international law. Or if it is applicable, for example, to Ukraine as well as to Lithuania, also respect to the European Union law, because there is European integration in the Constitution of Ukraine. This is also imperative of the Constitution to interpret the Constitution as far as possible in line with applicable international and European legal standards, and at least not to apply less favorable standards to human rights. Because otherwise there is no sense to provide such constitutional principles as respect to international law, respect to international standards of human rights, or geopolitical course. And here I must also, I would like also to share the experience of the Constitutional Court of Lithuania, that because we in our constitution have also such principles as open civil society. Open, that means also openness to the world, openness to the progressive development of international law. And that also means that in the practice of the Constitutional Court should take into account also the so-called soft law sources, such as Venice Commission documents, of course, when applicable. And once it refuses to take into account, it should constitutionally justify this refusal. But not only the Venice Commission, but as well as applicable progressive foreign practice. I mean, foreign practice of the foreign constitutional courts. And the Constitutional Court of Lithuania, for example, always review also all the applicable case law, all the relevant, let's say, not applicable, relevant case law of the foreign jurisdictions, foreign constitutional courts, and it should justify once it refused to follow the example of progressive foreign practice. That is also the point I wanted to stress. And the very last point, we should also remember, I think, that at least in the practice of the Lithuanian Constitutional Court, that the acts of the Constitutional Court, they are not only interpretative acts, they are also the acts of administration of constitutional justice. So from that provision, that the Constitutional Court is also the institution of administration of justice, sometimes the Constitutional Court can, for example, derive the power to reveal the consequences of its own decisions. Then there is a danger that those decisions can be, let's say, misunderstood by the, let's say, appropriate state bodies, or just to avoid some derogations. And like an example, I can mention, for example, because the acts of the Constitutional Court should not only rule on constitutionality of a disputed legislation, but should also be just, not in the formal understanding of justice, but also should be just according to the circumstances of a given case. And I can mention, for example, again, 2 years ago, the Lithuanian Constitutional Court for the first time faced the legislation which was impossible to implement. It provided for the obligation for the competent state authorities to verify all the studies programs of all universities in Lithuania in 2 days. That in 2 days it is clearly impossible. So some universities had been verified, but only a few of them. And when deciding on the consequences, the Constitutional Court, just relying on the provision that it is the institution administering justice, it pronounced that the decision that the law in question was recognized unconstitutional, it also means in the given circumstances that no legal consequences can be recognized for any universities. Because otherwise this decision wouldn't be simply just. So I would like also to add one small point, that sometimes the Constitutional Court should realize that it is also the institution administering justice, and to provide not only formal decision on constitutionality of legislation, but also to explain the consequences of its decision, so as to avoid any misunderstanding or any possible derogation in the implementation of its decision. So, дуже дякую за увагу.
Дякуємо вам.
Thank you very much. I would.
Thank you very much. And let me again thank Mr. Broker and Mr. Arnold and Mr. Shalimas and Mr. Rogov for their participation. We exhausted our program with the exception of 2. Oh, Mr. Ryshkov is here. Let me give the floor to Gennady Ryshkov, legal advisor with the Journal Foundation for International Legal Cooperation. Thanks very much.
Чутно мене?
Чутно.
Я сподіваюся, що чутно, може мені хтось знак якийсь подасть. Окей, дуже дякую. Я дуже коротко, бо звичайно...
Well, I'll be very brief. I'm the last speaker for today. You must be waiting for the end of this event. And it was a very interesting event. I want to greet everyone on occasion of the Day of Constitution. The Constitutional Court of Ukraine is protecting the Constitution from multiple changes that are initiated throughout the nation. I am also glad to see you all so healthy and robust. I'm glad that you are ready to communicate online, which stresses once again that we are all big aficionados of constitutional justice. I'll make just a number of remarks and I'll try to address the questions raised by the moderator. First, I will refer to what Dr. Brocker and Professor Arnold said about interpretation of the Constitution. It is a great obligation given the calling of the Constitutional Court, especially in the context of Ukrainian realities. Let it be the Constitutional Court and not the lawmaker who may also amend the Constitution. Interpretative acts of the Constitutional Court may be more conducive to further development of the Constitution without amending its text. As Professor Arnold stressed, the Constitution is to be a living instrument, and this is what the Constitutional Court can ensure by interpreting the norms of the Constitution in the context of the developing society. And we are aware of multiple such examples, especially as regards protection of social rights or protection of gender equality or same-gender marriages, etc. And many decisions of the constitutional courts, like in Germany, promoted changes without changes into the text of the Constitution. And this, in my view, is a better way than to amend the text of the principal law of the state. Acts of the constitutional courts as interpretative acts should always be properly grounded with all details. Pretty often constitutional courts in the former Soviet Union countries especially write short decisions. It may seem they are afraid to explain their views. Maybe they anticipate changes in the constitution, while in Germany I've seen drafts of rulings that were 400 pages long. The bulk of this volume being the motivational part, and that is so important for the development of constitutionalism, because what can be more important than a proper explanation of the position of the constitutional court? And all that is about development of constitutionalism. A voluminous explanation or motivation also testifies to the responsible attitude of the constitutional court. And if in the future the court decides to derogate from its initial position, it will have to explain why, even in greater detail, which makes judges more responsible to their work and which also sends a message to the addressees of the decision. It also disciplines the Constitutional Court and its judges. This is what I wanted to impart about these two aspects. And since I represent the Foundation for International Legal Cooperation, and since the case law of the Federal Constitutional Court of Germany was often referred to, I suggest we continue our cooperation offline. And let me now address a passage of the law on execution. I think the German colleagues expressed the position. Ukrainian realities are different from those in Germany. But one should really be cautious, and I think that other foreign participants also said that execution of the judgments of the Constitutional Court is to rest upon credibility of this court and on respect of other bodies to the Constitutional Court. Well, if there is a law on execution or on enforcement, then some sanctions probably should be provided for, and that is the risk of turning the Constitutional Court into a policing authority. And if relevant powers are vested with another authority, other risks may appear. That's why I'm skeptical. Well, thank you very much for your attention, and I wish good health to you all. Thank you, Gennady. I thank all participants of the fourth panel. That's the end of our proceedings. And let me give the floor to the Vice President of our court. Thanks very much. Well, we are to wrap up the event. We have 14 minutes for that. And it would not be fair on my part not to offer the floor to my two colleagues present here. We still have some time for that. Ola, what about you? Yes, we are about to celebrate, and our colleagues from the Venice Commission are marking their jubilee. The Constitutional Court of Ukraine has been protecting the constitutional values for quite some time. Today we have identified some issues, and maybe we don't have to count on 25 or 30 years. Maybe we should do more research right now. We are guarding the Constitution. We have to do it in the best possible way. And maybe we should think about improving the procedures available to the Constitutional Court to make them better defined, to make them enable the Constitutional Court reach the results it's supposed to reach. Yes, there are shortcomings in this format of communication, but I'm quite glad with what we managed to achieve. Thank you. Thank you, Helena. What will you add? It was a great pleasure for me to attend this event and to hear from top-level professionals about interpretation of constitutions and interpretation of laws. I was recently appointed to the Constitutional Court, and I am very attentive to what my colleagues think. I thank you very much for how you assessed the decision of the Constitutional Court on the constitutionality of Article 375, where I was the rapporteur. We had discussions about interpretation of this article, Article 375, whether we were debating whether to pronounce it unconstitutional. All the thoughts that were expressed today out of much instruments, all the ideas we heard are very professional. I thank everyone who participated for this very interesting day and this very interesting academic discussion. I wish success to everybody. I congratulate all citizens of Ukraine and all friends of Ukraine on occasion of the forthcoming Day of Constitution. I congratulate the Venice Commission on its 30th anniversary. And let's hope that very soon we'll be able to meet each other face to face, not online. Well, I acted as the moderator of panel 4, and I want to say now something about what we are working on and about how we understand the role of the Constitutional Court. There are two things here. The founding fathers of our Constitution 24 years ago developed the model of constitutional jurisdiction, thinking first and foremost, as we believe, about such a role of the Constitutional Court as ensuring the system of checks of balances for separation of power in Ukraine. Before that, Ukraine never knew real separation of powers, but the tradition has appeared. What was something usual for Western democracies, what was the culture of communication between powers came to Ukraine, it is still being developed. If we analyze the decisions of our court of the last 2 years, we may say that never before the Constitutional Court has played such a big role regarding the branches of power, regarding the arms. And I think you will agree with me. The other thing we have to remember to mention today is what we are criticized for, fairly criticized. That's the quality of our decisions and of their motivational part. Nearly all speakers mentioned this aspect. The last one to speak about that was our good friend Gennady Rushkov. The issue exists. This issue cannot be resolved overnight. This is something that we inherited from the previous compositions of the Constitutional Court. What we have to be attentive to is how we interact when we motivate and ground our decisions, how we interact with the academics, with those who develop the doctrine, constitutional law as a realm of knowledge also has to improve in the context of today. Several speakers also hinted at the need to take into account the opinions and rulings of the constitutional courts of other states with more experience in the spheres of rule of law and constitutional law. I am certain that in the motivational part of each our decision, there should be something about the respective views of our colleagues from the constitutional courts of other countries who share with us the principles of rule of law, respect of human rights, etc. I think that the Constitutional Court of Ukraine is making progress in this regard. Further cooperation with our foreign colleagues and with the Ukrainian academics are paramount, as well as with the scholars from other European countries with more developed traditions of constitutional jurisdiction. I thank everybody. And now I will say something to those whom I see in those boxes or windows on the screen. Do you have any questions? Do you want to say anything at this stage of our proceedings?
I cannot see the volunteers for final remarks. Hence, I would share my impressions of this event that we participated in, that we co-hosted with the Venice Commission and with OSCE PCU, that we generated together. This has been a very symbolic event. On the one hand, we actually celebrated the 30 years of the Venice Commission, a powerful European institution that has been serving for 30 years the cause of democracy and rule of law. On the other hand, we are celebrating the 24th anniversary of Ukrainian constitution, which is quite young. And I encourage all of us to celebrate together since the constitution is of great value to the Ukrainian society, to the Ukrainian people, and to the Ukrainian state. Perhaps not everyone has yet accepted it, interiorated it as the value of the state, but it is an axiological value to all of us, I'm sure. And I would reiterate that I cannot imagine a situation whereby Ukraine would preserve its European integration prospects without the role of the Venice Commission. On the other hand, these 30 years, starting with the 16th of July 1996 or 1990, were very challenging for Ukraine on its path of transition from authoritarianism to true democracy. This complicated, complex development of Ukraine has been accelerated, but it is not very even. It's not very very smooth. It is still very challenging and difficult. And in the most difficult times, Venice Commission should always stood by our side, starting with the assessment of the draft constitution, then to the text of the constitution itself, and their opinion that the text of the constitution should stand the test of time. And now we can see that it can be further improved, and the Venice Commission is helping us to improve it. And I cannot imagine us being able to preserve our European integration prospects without powers that be in Ukraine listening very attentively to the position of the Venice Commission and other international institutions, including the Council of Europe and its institutions, the General Directorate for the Democracy and the Rule of Law, including the institution that supported us in organizing this conference, that is OSCE. It's the International Fund for, or the German Fund for International Legal Cooperation, and the justices of constitutional courts of Germany, Lithuania, Kyrgyzstan, Kazakhstan, all of us working together contribute to achieving our common goal. And Ukrainian experience of transferring from authoritarianism to democracy is a demonstration of our common achievements. And that is confirmed by the Latin proverb, gutta cavat lapidem. And every one of us actually contributes one drop to break this stone of totalitarianism, of the lack of rule of law, lack of democracy, lack of personal freedoms and rights, human rights. So in the preamble and 3 articles of the Constitution, we reflected our ambition to become fully fledged members of the European Union and NATO. I thank all of you for our cooperation and for participation in this event. I wish we could meet face to face, of course. I understand that we can discuss challenges of Ukrainian development, of this transition from the dark night to the light of democracy is exasperated with this global pandemic whereby the entire globe suffers. So I will join you in your opinion that we will live and wait till we can see one another when we be able to meet physically in person. See you later, and I wish all of you to be safe and healthy. You, your parents, your children, your families, your friends, all who you hold dear, may you be healthy and safe, and may we meet together very soon to hug one another, to shake hands, and to enjoy life and work together to our common mission. Thank you very much.